Okay, good morning. Before we get started, I'd like to ask everyone to please take a moment to put your cell phones on silence so we can give our full attention to today's board meeting. Welcome to the quarterly board meeting of the Osteopathic Medical Board of California. This meeting is being held on August 14th, 2025, and the time is 9:03. This meeting is occurring at Touro University College of Osteopathic Medicine, Mare Island, located at 1310 Club Drive, Vallejo, California, 94592. Today's meeting will be run according to the Open Meetings Act as required by law. The meeting will be conducted using the following guidelines. The board welcomes public comment on any item on the agenda, and it is the board's intent to ask for public comments prior to the board taking any action on an agenda item. During each agenda item, the host moderating this WebEx event will activate the Q&A feature of WebEx and will ask anyone wishing to make a public comment to indicate so by replying yes. The host will then call on individuals who indicate they wish to make a public comment by the name that they joined the WebEx event as. When called upon, the host will unmute the microphone of the individual, and he or she will have 3 minutes to make his or her public comment. The host will audibly announce when 15 seconds remain to conclude the public comment. After the 3 minutes have passed, the individual will be placed back on mute. Only one public comment per agenda item is allowed per attendee. All participants will mute their microphone or their phone during each presentation of the agenda topic. At the conclusion of the discussion of the board members, I'll ask for a public comment. At the conclusion of the discussion period, I'll call for a vote if necessary or move to the next agenda item. All in attendance should keep their comments specific to the agenda item being discussed. Any board members attending remotely, and I believe we do have one, must be visible on camera the entire time, unless there are connective issues. The member must disclose that information prior to going off camera. And then remote board members, which we have one, must disclose whether other individuals 18 and above are present and the general nature of their relationship. The opportunity for public comment for items not on the agenda will be provided. Please be advised that during this comment period, the board cannot engage in discussions or take action on any matter that is raised, except to decide whether to place the matter on an agenda item for future meetings. We are now going to establish a quorum, and I'd like to call the meeting to order and ask for a roll call by Machiko. Good morning.
Present.
Present.
Good morning, present.
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 Great.
Madam President, if Mr. Adamian can state whether or not there is anyone in his room, that would be great.
There is no one in my room.
Okay, perfect. Okay, moving to agenda item number 3, public comment on items not on the agenda. During the meeting today, public comment is welcome on any agenda item as that item is being taken up by the board. Please be aware that public comment during this agenda item should provide information to the board members and is not a discussion between the board members and the public. The only action board members can take is to listen to the comments and decide whether they want a future agenda item on the topic. No other action can be taken on this item at this meeting, though I know this may seem at times like the board members are not being responsive. Following these guidelines is critical to ensure the rules of the Open Meeting Act are followed and to avoid compromising the speaker's goals or the board's mission. In order to allow the board sufficient time to conduct its scheduled business, the board will limit the time given to each person to 3 minutes. It is not necessary to repeat statements or views of a previous speaker. It is sufficient to just state that you agree. As a reminder, please do not disclose details of an active enforcement case or licensing matter. Such discussions are considered ex parte communications, as they could provide information to members that is outside of the record and in violation of the Administrative Procedure Act. Therefore, such discussions could create a conflict and lead to board decision being challenged in Superior Court. The board can receive comments regarding the board's processes in general, but it cannot receive comments on specific case circumstances where decisions are still pending. In addition to the board would like the public to address the board as a whole and not individual members. The board appreciates your cooperation and assistance in meeting its legal mandate. And if you want to comment on an agenda item, please wait until we get to that agenda item. Comments at this time are only for items that are not on the agenda. Again, you have 3 minutes. And at this time, are there any public comments from any members of the public who are in the room? I see none. Moderator, is there anyone requesting a public comment online?
This is the moderator for members of the public on WebEx. If you would like to make a public comment for items not on the agenda, please click the raise hand option, or if you're an audio only participant, you can press *3 on your device. All right, and it appears there are no requests for public comment at this time.
Okay. We will then move to agenda item 4 and 5. We have 2 early termination of probation petitions, and I'm going to turn the meeting over to our administrative law judge, Julia E. Cox. Judge Cox, the floor is yours.
Thank you. The first of the 2 petitions, as I understand it, is by Dr. Stephen Dwayne Western, a petition for early termination of probation. Is Dr. Western present, either in the room or on video? All right, that's you, sir. Please come forward and take a seat here at this table if you would. For everyone's benefit who's here, I am an administrative law judge from the State Office of Administrative Hearings, and I'm going to be sort of facilitating this hearing. And we have a court reporter present who's going to take down what we say so that we make a clear record of what we discussed and what was presented during the hearing on this petition. So, Madam Reporter, are you ready to go on the record? All right, let's go on the record then. Good morning. We're now opening the hearing on the petition for early termination of probation by Dr. Stephen Dwayne Western. This matter is Osteopathic Medical Board of California, case number 9002020000575, and its Office of Administrative Hearings case number 2025-070348. As we heard earlier, today is August 14, 2025. It's shortly after 9 o'clock in the morning, and we have convened here at Touro University in Vallejo, California for this hearing. I'm Administrative Law Judge Juliet Cox from the California Office of Administrative Hearings, and I will be presiding over this hearing. I'd like to start by asking the representatives here to introduce themselves, and I will begin with counsel from the Attorney General's office, please.
Thank you, Your Honor. My name is Christopher Young. I'm the Deputy Attorney General here on behalf of the Attorney General of California.
Thank you. And Dr. Western, if you would introduce yourself, please. All right. Madam Reporter, can you hear Dr. Western enough, or does he need a microphone? There are a couple of... Okay. That one's, yes, that's helpful. So, thank you. All right. Dr. Western, do I understand that you're going to represent yourself today?
Yes.
Okay. Let me just take a moment and explain to you what we'll do here. The board members have received your petition, and I believe they've received some other supporting documents as well. What I'm going to do first is I'm going to invite Mr. Young to explain the circumstances that led to your being on probation and now petitioning to terminate it. And he's also going to describe one by one the documents that have been provided to the board and that that should constitute the documents that they'll review in connection with your case. Do you have any concerns about any of the documents he describes? And I see you don't have any documents in front of you, but I assume you're familiar with them, and if not, say so. At any rate, he'll describe those things for us, and we'll make sure that we have the appropriate set of written materials to look at. Then I'll turn the floor over to you. I assume that you're here because you would like to testify in order to supplement the written materials that you supplied with your petition, supplement that with testimony describing the circumstances that lead you now to petition for early termination. When you've done that, so I'll swear you in and you can give us the information you've come to give. I'll permit Mr. Young the opportunity to ask questions of you because he will assist in developing a complete set of information. And it may be that some of the board members also will have questions for you. Did you intend to have anyone else testify on your behalf today, or will it be only you?
So it's not so.
Okay, so after we finish with that, then we will conclude that part of the hearing. The board will deliberate a bit later in closed session, and you'll receive a written decision on your petition sometime soon thereafter, after the board has made its decision and it's been drafted in writing and signed, and then you'll receive it from the board. So I don't believe the board intends to come out of its closed session and announce its decision right now. Instead, they will deliberate and instruct me on what to draft as a written decision, and you'll get that decision later. Does that all make sense to you? Okay. Mr. Young, how would you like to begin? I would appreciate your introducing this case, as I mentioned, explaining the circumstances that bring us here, and discussing the documents that are provided for the board's review.
Yes, sir. This is a petition to
Apologies, this is the moderator. It's very difficult to hear the petitioner on the WebEx call. I'm not sure if there's something wrong with the mic or if they just need to get the mics closer. Additionally, it's also very hard to difficult to hear the AG.
Okay.
Could you try speaking one more time?
Check. Hello, this is the change.
This is the moderator. There seems to be a lot of echo, and it's difficult to make out what you are saying.
Off the record for a moment, please. Let's see if we can troubleshoot this without having our court reporter take it all down, but I do want to make sure that people who are attending remotely can hear everything. Are you able to hear me well enough, Madam Moderator?
Yes, this is the moderator. I can hear the people at the table just fine.
Okay, so these microphones at the table are feeding sound into the webinar well, but the portable mics that are at the tables in front of us are not. Is that what I understand? Well, now we could move these to the tables. Okay, see if there's something you can adjust, and if not, since we have a couple of empty seats up here, we could move. Yeah, we could conceivably put these out there if the cords are long enough, which they don't look long enough. Sorry to interrupt you, Mr. Young.
Check, 1, 2, 3. Check, check, check. Check, check. Check, check. 1, 2, 3. Check, check. Check. Stop.
Yeah, those microphones are fine for amplifying sound in this room for us.
I think it's nuts.
Yeah, that seems to be the case.
People that might integrate in as well. So that's
Hello, sir. I think we're having trouble with the handheld mics. They're not feeding back in for some reason. So I think we'll just take a 5-minute break and we'll try to set up some of these wired microphones.
Okay, perfect. Thank you.
Okay, thank you.
Yeah, we'll go on a 5-minute break.
Sorry about that.
5 or 10-minute break, and then we'll return.
All right.
Okay. We've returned from our break. Okay. We're going to do a roll call.
Corey Damien.
Present.
John Cummins.
Present.
Can you hear me? Sarah, is this fine?
Yes, that's perfect.
Okay. Brett Lockman. Andrew Marino.
Present.
Hamesh Patel.
Present.
Denise Pines.
Present.
Matthew Swain.
Present.
Quorum has been established.
Okay, I think we're ready to resume. So let's go back on the record. We're back on the record, and I hope that those who are attending remotely can now hear us a little better. I neglected before to ask our reporter to announce her presence and CSR number as well, so that the record will include that information. Madam Reporter? Thank you. Now, Mr. Young, when we stopped for a moment, it was because they could not hear you remotely announcing the information about how this case came before us. So if you would begin again, please.
Yes, Your Honor. It's for Young, Deputy Attorney General. And just check.
Apologies. Could the AG get a little bit closer to the microphone, if at all possible?
It's not on. The other button. the lower one.
There we go. Lower button.
Okay, good morning. Can you hear me?
Yes, now we can hear you.
Okay, thank you. The mic is on. My name is Christopher Young. I'm a Deputy Attorney General, and I'm here representing the Attorney General of California.
I believe you had introduced yourself earlier, and I was ready for you to give us the overview, please.
Okay, yes. This case originated out of a disciplinary order signed by this board and made effective October 10th, 2022, concerning Dr. Western. And today he is petitioning for early termination of his probation. We're here today to discuss the grounds for his petition, the nature of his rehabilitation, and whether his probation term, which was originally set by this board as a 4-year term, should be reduced by, well, effectively 1 year. He's served practically 3 years of probation. He's complied with the terms and conditions of probation. Today is his opportunity to present evidence of rehabilitation to show that he has learned from this experience and the disciplinary order of this board, and that the items in the disciplinary order are no longer a concern and that probation should be granted. I've uploaded exhibits to our case center, and there are 7 exhibits labeled A1 through A95. I provided a copy of those exhibits to Dr. Western on Thursday, August 7th, and I've provided him a paper copy of those exhibits this morning, so he has them in front of him.
Would you go ahead and describe what they are, and we can make sure that there's agreement or disagreement between the parties as to whether they should be considered. If there's disagreement, I of course can rule on it, but let's hear what they are first.
All right, thank you. First, I'd like to present exhibit number 1. This is the petition for termination of probation filed by Dr. Western. This also includes his narrative statement. This includes 2 letters of recommendation, one from Dr. Eric Palmer, that's Palmer, and another by Dr. Mark, M-A-R-C, Hoffing, Hoffing. Dr. Western has also submitted his own declaration in support of his petition, and those documents are labeled A1 through A35.
Thank you. Dr. Western, is that document that's Exhibit 1, pages A1 through A35. Is that an accurate copy of the petition that you submitted with its supporting attachments that you wanted the board to consider? Thank you. When you speak, you'll need to push that green button to make sure that you're audible.
Yes, it is, Your Honor.
Thank you. Then Exhibit 1 will be admitted. Mr. Young?
Thank you, Your Honor. Exhibit 2 is offered for jurisdictional purposes. This is the certification of licensure of Dr. Western, showing his license is valid and current.
Dr. Western, do you have any objection? Is there any concern about Exhibit 2 as a certificate summarizing your licensure with the board?
No concerns, Your Honor.
Number 2 is also admitted.
And next, Exhibit 3 is the notice of hearing marking today's hearing today at Touro University. And that's offered for jurisdictional purposes today.
Yes, to show why we are here today. Any objection to it for that purpose, Dr. Western?
No objections, Your Honor.
3 is admitted.
Thank you, Your Honor. And Exhibit 4 is the board's disciplinary order in this matter, imposing the 4 years of probation effective October 10th, 2022. This also includes the stipulation that was reached between the complainant and Dr. Western regarding the accusation that had been filed. And there's also a copy of the accusation included in Exhibit 4.
Dr. Western, do you have any objection, any concerns about number 4, to inform the board of why you were placed on probation and when?
No concerns, Your Honor.
4 is admitted.
Thank you, Your Honor. Next is Exhibit number 5. This is a petition for penalty relief report prepared by staff of the board concerning Dr. Western's compliance with probation terms.
Okay. Dr. Western, do you have any objection to number 5 becoming part of the information the board considers?
No objections, Your Honor.
5 is admitted.
Thank you, Your Honor. And next in the packet is Exhibit number 6. These are progress reports confirming Dr. Western's submission of quarterly reports in compliance with the term of his probation.
Okay. And just to be clear, these appear not to be Dr. Western's reports, but rather summaries by board staff members of the information that Dr. Western reported. Is that correct?
Yes, that's correct, including his compliance with other terms, including cost recovery payments, quarterly reporting requirements, and the dates that he completed the required education courses as well.
All right. Dr. Western, do you have any objections to Exhibit 6?
No objections, Your Honor.
6 is admitted.
And the final exhibit, Exhibit 7, is simply petitioner's acknowledgement of receipt of the notice of hearing and his agreement to appear today. He's here, so there's really no need to include it, but that was just in case we didn't see Dr. Western this morning.
All right. Dr. Western, do you have any objections to number 7 becoming part of the record just to make it complete?
No objections, Your Honor.
7 is admitted. And then I just want to state, to make clear that in the additional documents segment here on Case Center, just for my own use and as well as for clarity, I uploaded a copy of the Osteopathic Medical Board's disciplinary guidelines from 2018. I believe that those are the board's most current disciplinary guidelines, and I wanted to make sure that they were readily available for anyone to consult. So those are there as well. Anything else that you would like to say, Mr. Young, before I turn the floor over to Dr. Western?
Yes, just to set the groundwork for our petition hearing today, the disciplinary order is based on a stipulation arrived at between complainant, the executive director of the Osteopathic Medical Board, and petitioner Dr. Western. Now, in that stipulation, and this is at page A61, or I'm sorry, A65, in the exhibit number 4, paragraph 15, the disciplinary order stipulates that the charges and allegations in the accusation shall be deemed true, correct, and fully admitted by Dr. Western, with the exception of what's referred to in paragraph 9 of the order, regarding prescriptions of pain medications, Percocet. That is not something that we're going to be relying on here today, or that should be considered by the board. But all other allegations in the original disciplinary order are deemed fully admitted by Dr. Western. And I just wanted to establish that at the beginning of today's hearing. And with that, I'll turn it over.
All right. Dr. Western, am I correct in thinking you'd like to testify to speak to the board about your petition?
Yes, Your Honor.
Would you please raise your right hand? Do you solemnly swear or affirm, under penalty of perjury, that the testimony you will give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Thank you. Please, the floor is yours. You may tell the board in your own words what you'd like them to know to go along with these documents. And then, as I mentioned, Mr. Young or members of the board may have questions to ask you, but you should begin in your own words first.
The charges were brought before me were based upon,
And let me ask you to do two things. First, be as close as you can to that microphone and try to speak relatively slowly, both for the benefit of those who are listening remotely and for our court reporter.
okay,
Sorry to interrupt you. Please go ahead.
basically, I had just a major concern for a family member, and it's someone who needed just a lot of help in their life. And basically, over that concern is the reason why I did what I did. It was just out of pure, just trying to help them as best I could, and not out of any trying to commit any harm to them or anything malice of forethought or anything like that to them. So that was the reason why I ended up helping the individual that I did help. And that's what ended up getting me here today.
Okay. Is there anything else you'd like to say in your own words about what you've done on probation that leads you now to ask to terminate it effectively a year and a little bit early?
I've been in compliance with everything the medical board requested of me, did all the programs that they requested, did all my CMEs that was basically requested to maintain my medical license. The person in question who had helped at that time, I had not helped since then. And basically just I've done everything that I could just to be in compliance.
Okay. Mr. Young, do you have any questions that you would like Dr. Western to answer?
Yes, Your Honor. Thank you. So Dr. Western, the board may consider any activities you've engaged in since disciplinary action was taken. By your proffered evidence, including your narrative statement and your declaration in exhibit number 1, there seems to be a contradiction. Well, is there anything in the documents that you've done differently in your medical practice since October 2022 when discipline was imposed?
Yes, at the time, I had done a handwritten record for her just because of the fact that I didn't want to go into the billing cycle of my EHR. So I did it in that regard like that. But since then, it's like I have not done anything like that again. I've done nothing but my EHR records only.
All right. And what is your specialty as an osteopathic doctor?
My specialty is family medicine.
And you're not board certified to practice psychiatry, correct?
No, I'm not.
You've never completed a residency in psychiatry, have you?
No, I'm not.
If a patient presents to you now with complex psychiatric conditions, such as dissociative identity disorder, would you feel confident in treating the condition?
I would refer them to the psychiatrist.
Now, there were some statements in your narrative statement supporting the petition that I'd like to discuss. This is Exhibit 1 at page A4. Now, you state that here, there are a few things I just wanted to go over. The first is you state that the care that you provided to patient A, we'll term her that, was rendered after your romantic relationship ended. This appears to be attempt to defend that you were not treating a family member. How can you explain that?
Well, I consider them a family member because we have a child together. So I've always looked at her like she's family, even though my relationship with her ended. I've always just basically helped her out financially and just looked after her financial needs, things like that.
Okay. Now, the facts deemed admitted for today's hearing are found at page A75, and this is in exhibit number 4. And that is that you had a romantic relationship beginning in 2011. The relationship ended in or around June of 2012. You had a child born by patient A in December of 2012. And then you began treating patient A on January 21st, 2013. Is that correct?
Yes, that's correct.
So in your narrative statement at A4, you state that the medical care provided was over a year after relationship ended. Was that an inaccurate statement?
I'm going back that many years. I'm somewhere around there.
All right. But you have no reason to dispute the facts in the accusation and the timeline that I just laid out.
No reason to dispute.
All right. Now, this board has found that your treatment of patient A for dissociative identity disorder, it may be referred to today as DID, was in fact gross negligence. Do you disagree with that finding?
It's kind of a hard answer to call on that. Over the years, she had been seeing quite a few different psychiatrists, and only one of them could even told her that they thought that she had dissociative identity disorder. The rest of them said they weren't sure, and basically because they weren't, none of them were ever sure of it, none of them ever treated, but the treatment isn't just a psychological treatment on how to deal with the alters within dissociative identity disorder. So basically, I started reading up on everything that was available on the disorder, and I found that basically alters to be able to deal with them from that perspective had to be integrated. And even though all the literature I read to integrate any kind of an alter. So I started researching it and looking into it. And with all the years that I ended up spending with her and trying to help her with her condition, I figured out a way to actually integrate an alter. So I helped her with that, and I helped her at the time integrate her alter so that way she could function more normally. And as far as the board's saying that, like, as far as the board's position that I negligence, then I would agree to them that I did under those particular circumstances, regardless of what my intention was, because I did that and the act was perceived by the board to be negligent, then I agree with them.
All right. And you agree that it's gross negligence to practice psychiatry on a family member, correct?
Yes, I agree.
All right. In your narrative statement at A4, you wrote, I know more about dissociative identity disorder than any psychiatrist or psychologist around. Do you stand by that statement today?
Well, I can say that I've probably logged in about 10,000 hours of time trying to figure out how to, for her to ultimately deal with the situation. My knowledge base is extensive, but at the same time, I'm not the expert. And I'm not a psychiatrist. So my agreement to the board is that, yes, I did exactly what they say I did. So my position is that I don't practice in that regard anymore. As far as if I ran across another patient who had a problem like that, I would turn them over to psychiatric, whoever their psychiatrist is as a choice.
All right. And one other statement you made was that patient A, after your treatment, is doing better now than she ever did before. By that statement, are you intending to represent that you're qualified to practice psychiatry?
No, I'm not.
All right. There's one other issue in this narrative statement is that you claim you created a clinic note for each time you treated patient A, and that's at the bottom of page A4. However, that's in contradiction to page A80, and that's in exhibit number 4. In A80, you agreed to that you were negligent by prescribing diethylpropion for weight loss. That's diethylpropion without documenting adequate reasons and vital signs such as body mass index. Do you, by stating that you created a clinic note for each time you treated her, are you disputing the findings that your medical record keeping was inadequate?
It was inadequate.
All right. And then finally, as to the weight loss medication you described, you claim in page A4 that it was a safe medication indicated for pregnant women, and it appears that you're claiming that you had prescribed it in a non-negligent manner. However, the findings before today's board at pages A78 and A79 that you agreed to are that it was negligent to treat patient A with weight loss medication. Do you have any comment on that?
Based on the time, just what the literature said, I was believing that it was safe enough, but at this point in time, based upon reflection upon it and what I've learned from dealing with my disciplinary actions that were rendered upon me, I agree with you that it was negligent and that I stopped doing that.
Okay. I have no further questions. If the board has questions, or Your Honor.
Certainly. Does any board member have questions? I can call on you by one, or I can recognize anyone who's raised their hand and has any question. Perhaps we'll start with Ms. Pines. Do you have any questions?
I do not.
Okay. Do any of the other board members have any questions that you'd like Dr. Western to address?
Your Honor, question.
Yes. Would you please identify yourself for the record before you ask it, and then go ahead?
Yes, of course.
Good morning. This is Board Member Andrew Moreno. Question, I know when the DA was asking you about, I believe your record keeping, you mentioned EHR.
I'm sorry, I'm having a hard time hearing you.
When the DA was asking you questions, I believe related to your record keeping, but I could be mistaken, you had mentioned something along the lines of EHR.
Yes,
As a member of the public who's not a licensee, can you explain to me what that means?
electronic healthcare record.
Okay. And what was the issue related to that?
It was deficient in some of the information I should have put in the EHR as far as weight loss is concerned, like, for example, BMI, which is based upon a person's weight to height index. If a person's weight to height index is above a certain point, then they're considered overweight versus, those things are determined whether the person's overweight, underweight, or normal weight. And my record was deficient in that.
Please speak up.
Oh,
Yes.
okay. So basically, my medical record was deficient in the fact that there was no BMI noted in my medical record when I was doing the weight loss. And I should have had that noted every time.
And do you do that now?
Yes, I do.
Thank you.
Are there any other questions from any members of the board? Including our member who is there on video. No, I see no questions, no hands raised.
No questions.
Thank you. Yes.
Judge Cox, if I may correct the record, we are going to be sending you our copy of our disciplinary guidelines because I think it was the wrong version that you quoted.
Okay.
So we'll be sending you those
Very good.
guidelines.
The most recent guidelines that I have in my office were approved in 2018. So if there is a more recent
It's
set-
actually a later version. It's
Right.
the 1996 guidelines.
Okay.
Yes.
So maybe you can explain why we have one that's from 2018 when the 1996 is actually what you rely on.
Yeah, the 18 one were presented to the board members, but they were not fully adopted.
Thank you.
You're welcome.
All right, I'll take that information back to my office. Okay. Erica Calderon? Thank you. Okay, so I heard no other questions for Dr. Western. Dr. Western, is there anything else that you'd like to say that you've thought of because of the questions that were asked to you?
Yes, just that the concerns that the board has had concerning my practice of medicine, that I have corrected all the issues and I don't do the things that they discipline me for anymore.
Thank you. Mr. Young, is there any rebuttal evidence that you'd like to present?
No, Your Honor.
Okay, then before we wrap up this hearing regarding Dr. Western, I would like to hear some summaries from you. I think you've summarized your position. Is there anything else you want to say? Or have you said everything you want to say?
Pretty much said everything, Your Honor.
All right. Mr. Young, is there anything that you'd like to say in summary about this petition?
Yes, thank you. Just briefly, petitioner has the burden to affirmatively show rehabilitation from the misconduct that underlies this disciplinary action here. And he must do so by presenting clear and convincing evidence of rehabilitation. There's a legal citation for the court's benefit at Houseman versus Board of Medical Examiners. That's Housman. And the citation is 1948, 84, Cal App 2nd, 308. And the pin site is page 316. It's petitioner's burden to produce affirmative evidence of rehabilitation to reassure the board that such misconduct will not reoccur and in order to protect the public. In fact, the probation should only be reduced if by evidence petitioner acknowledges his misconduct and shows he has developed tools to ensure it will not be repeated. Dr. Western here is not in the position of an untried newcomer seeking a license, but he's a fallen licentiate. So the board must be exacting in its requirements of proof of reform. And Dr. Western has presented 2 letters of support from professional acquaintances, and those can be seen at pages A6 and A5. And I referred to those doctors earlier. Neither doctor seems to comment specifically on Dr. Western's practice, but as a more general recommendation for the termination of probation. And then Dr. Western's testimony here today can be considered along with his narrative statement and his declaration. And those are in exhibit number 1. And we've discussed them with him today. The narrative statement, however, raises some questions, and I believe Dr. Western has addressed all of them today. And on that basis, petitioner's proof of rehabilitation today is submitted to the court for its decision.
Thank you. All right. Anything you'd like to say as the last word, since, as Mr. Young said, it is your burden to persuade this board that it should terminate your probation early?
As far as, yes, I feel that I have completely rehabilitated my actions and corrected everything that I needed to correct. And basically, I've done everything I'm supposed to do as far as going forward from the time that I was put on probation. I have not done any of the things that I was accused of, and I will never do that again.
Thank you. All right, that will conclude the evidence gathering component of this hearing regarding Dr. Western. As I said, the board will deliberate later in closed session and then send you a written decision on your petition. Thank you very much for coming today to address the board. We'll go off the record.
Thank you, Your Honor.
Don't go away quite yet, because what I'm going to do is ask our reporter to tell me approximately how many pages a transcript of your hearing might have. And I'm going to give you this paper that's going to tell you how you would order one if for some reason you wanted it. So 25 pages. Thank you. All right, this is for you, sir. Thank you. Okay. Thank you. So you may take your seat back in the audience. You may go wherever you're going today, because we have a second petition, so someone else is going to need that table.
Okay, thank you. Thanks, Adam.
Mr. Young, are you not going to present the other one?
So, my colleague, Miriam Abraham.
Okay, then hang on a moment. Let me give Mr. Young, let me give this to you as well. There we go. There you go. Thank you, Ms. Pine.
Mhm.
One of those for me and one for her. All right, I think we are. Ms. Pines, are you ready for our next agenda item?
We are.
Okay. And that would be our petition involving Dr. Lally. Dr. Lally, are you present? Wonderful. Please come forward and make yourself comfortable at this table here. And let us know when you're ready, all three of you.
I'm ready to proceed, Your Honor. Thank you.
All right, thank you. Madam Reporter? All right, let's go on the record then. Good morning. We are now opening the hearing and the administrative record in the matter of the petition by James Michael Lally for early termination of probation. This matter is board case number 900-2019-000097. It's Office of Administrative Hearings, case number 2025-070-590. Today is August 14, 2025. It is just before 10 a.m. and we have convened here in Vallejo at Touro University for this hearing. I'm Administrative Law Judge Juliet Cox from the California Office of Administrative Hearings, and I will preside over this hearing. I'd like to ask the other participants to introduce themselves, beginning with counsel from the Attorney General's office, please.
Yes, thank you, Your Honor. Good morning, Miriam Ahmad, Deputy Attorney General, appearing for the California Attorney General's office.
Thank you. And Dr. Lally, would you introduce yourself, please?
Yes, Your Honor. James M. Lally, DO. I would be the person appearing today.
The
Thank you.
petitioner. Thank you. And can I have our reporter please introduce yourself for our record?
Good morning, Maria Esquivel Parkinson, CSR number 1062 Black.
Thank you. Dr. Lally, do I understand that you intend to represent yourself here?
Yes, Your Honor.
And do I understand as well that you are quite familiar with how these hearings work?
I am familiar with them. Yes, yes,
All
Your
right.
Honor.
I understand from your background, I don't need to go over the explanation of how the hearing will be conducted.
You may if you wish, Your Honor. I'm not here to tell you that.
All right. I think we'll dispense with that. Ms. Ahmad, would you like to make any opening statement in the form of giving us an overview of how this petition came to the board and describe the documents that you have provided here that the board may review?
Yes, Your Honor, thank you. This is a petition for termination of probation. Petitioner entered a stipulated settlement agreement of the underlying matter. The board adopted the stipulated settlement and it became final on July 31st, 2023. As part of that stipulated settlement, the petitioner was placed on 3 years of probation. So petitioner is now 2 years into his probation term and he is requesting that probation be terminated. By way of background, I'll give a brief factual summary of the underlying cause for discipline. The petitioner had various professional roles throughout his career. He served as a faculty member, residency program director, as well as a chief medical officer at the Chino Valley Medical Center. This was from 2004 to 2018. He also served on the board in several capacities over the years. He served as a board member from 1998 until 2001, and then again from 2012 until 2018. He served as the board's president from 2000 until 2001, and then as medical consultant for the board from 2018 until 2021. Unfortunately, there are several allegations that arose while the petitioner served in those professional capacities. The allegations are of sexual harassment, of discrimination based on gender and national origin, creation of a hostile work environment, using his position with the board to intimidate residents, and failure to disclose conflicts of interest while serving as a medical consultant with the board. Today is an opportunity to hear any additional evidence that the petitioner may have in support of his petition. By way of exhibits, the Attorney General's office has uploaded the following exhibits. Exhibit 1 is the certificate of licensure. This is for the petitioner. Exhibit 2 is the accusation. And I'm happy to take this one by one if Your Honor prefers.
Why don't we do that? Let me ask Dr. Lally, have you reviewed these exhibits? Do you have any objection to Exhibit 1, or is it an accurate summary of your licensure history?
Your Honor is correct.
That it's an accurate?
Yes, ma'am. Yes, Your Honor.
Then 1 is admitted. Go ahead, please, Ms. Ahmad.
Yes, Your Honor. Exhibit 2 is the accusation for the underlying matter in this case.
Okay. Yes, I see. Yes, filed in 2022. Dr. Lally, do you have any objection to the board's receiving this accusation to understand the allegations that caused your probation to occur?
I do not, Your Honor.
2 is admitted.
Exhibit 3 is a copy of the stipulated settlement agreement and disciplinary order.
Okay. Do you have any objection, Dr. Lally, to number 3?
No, Your Honor.
3 is admitted.
Exhibit 4 is the petition for termination of probation and petitioner's accompanying character letters. He has submitted 2 in support of his petition.
And it looks as if there's also a narrative statement by the petitioner beginning on page 830. Is that correct?
Yes, Your Honor, that is correct.
Thank you. Dr. Lally, is Exhibit 4, in fact, the petition that you intended the board to consider with its supporting documents?
Yes, Your Honor.
All right, then 4 is admitted.
Exhibit 5 is a copy of the probation report documenting the petitioner's performance on probation thus far.
Okay, so yes, there are several reports and they appear to be summaries by a board member of information that the board probation monitor collected from Dr. Lally. Do you have any objections to Exhibit 5, Dr. Lally?
I do not, ma'am.
5 is
Your Honor.
admitted.
Yes, Your Honor. And finally, Exhibit 6 are the guidelines for the board. These are from 1996, which our understanding is these are the latest adopted guidelines by the board.
Fabulous. I will mark those as number 6 just to have them handy. And I apologize for my confusion earlier about any more recent guidelines. So those are, if there is any need to consider any disciplinary guidelines, those guidelines that are marked as number 6 from 1996 will be the ones that the board members consider. Is there anything else that you'd like to say, Ms. Ahmad, before we invite Dr. Lally to speak to the board?
No, Your Honor. Thank you. I'm ready to proceed.
Thank you. Dr. Lally, did you wish to speak to the board and testify?
Yes, Your Honor.
Would you please raise your right hand? Do you solemnly swear or affirm under penalty of perjury that the testimony you will give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Thank you. The floor is yours. You may address the board and explain what you'd like them to know beyond what's in these documents regarding your petition. And then Ms. Ahmad may have questions for you, or the board members may have questions as well, but you go first.
Thank you, Your Honor. May I have some notes in front of me? Is that okay?
Yes.
First, I would like to thank the board and Her Honor for taking time out of their day for this. This is a time frame issue ending at a time where I moved on. So one of the things I'd like the board to hear is that I'm no longer in the environment that was conducive to some of the allegations and accusations that were provided. I left the hospital setting in 2018 of June. My eldest daughter had passed in an accident, in May of 2018. So I had finally made the decision to go ahead and terminate that relationship. I have worked in a community access clinic that I put together. I still deal with students. I still deal with nurse practitioners and PAs and PA students. But one of the things that I've gotten, and this has really been a humbling experience, I'm not going to misrepresent in any way, shape, or form, but it's caused me to pause and reflect on how I've chosen to do things. I do have a military background. I make no excuses for that. And I had a tendency to probably run things that way. Some things that were said in regards to what went on, I'm not here to disprove them or to argue them because they were said in a proceeding that I chose to proceed in. I do take exception to one small issue. My mother is Indian. For me to be told that I was biased or racist against that particular race was, everything else I can live with, but that particular one has just been kind of a stickler with me. I believe I've made the changes. I've certainly been very, very thankful for my probation officer, Mr. Carrillo, who's been very direct with me and has helped me frame the things I needed to do. Why am I asking for this early? I want to show people that I actually did the process. I could wait this out and wait another year, and then I would be released from probation to go on with my life. But it was important to me that people understood that I took this very seriously. So I completed the tasks that were provided to me timely, and I feel effectively. I did benefit and learn from the ethics class that I took, because there's just some things you over time just put behind you, and as well as communications and civility. I've learned to read my audience, although some audiences are harder than others, but I've learned to at least accept and to deal with the fact that not everyone is on the same level or plane. So I want to, again, thank you for this opportunity. I'll stop there.
Okay. Ms. Ahmad, are there any questions that you would like to ask Dr. Lally?
Yes, Your Honor, thank you. Good morning, Dr. Lally.
Yes, ma'am.
First, I'd like to extend my condolences to the passing of your daughter. I know there's nothing that can say to make that better. My purpose here is to ask you some questions about the underlying case and then questions about your rehabilitation process so that we can have a fuller picture about your petition for termination.
Thank you.
So you entered a stipulated settlement agreement, which became final on July 31st, 2023. Is that correct?
Yes, ma'am.
And as a part of that stipulated settlement agreement, you agreed that if you were to ever petition for early termination of probation, that all of the charges and allegations contained in the accusation shall be deemed true, correct, and fully admitted by you. Is that fair?
Yes, ma'am, that's fair.
Now, you served in various capacities on the Osteopathic Medical Board, correct?
Yes, ma'am.
And you also served for quite some time at the Chino Valley Medical Center. Is that correct?
Yes, ma'am.
Now, during your time as program director and as chief medical officer at Chino Valley Medical Center, there were several allegations that were raised against you. Is that correct?
Allegations, yes, ma'am.
Okay. Now, I want to walk through some of these allegations. Isn't it true that the residents at Chino Valley Medical Center raised allegations of sexual harassment and inappropriate touching committed by you?
They did raise that, yes, ma'am.
Okay. Now, there were over 30 witnesses who were interviewed, and they reported that you touched female residents in an inappropriate and unwelcome manner. Is that correct?
That's not correct, because you're making it sound like all 30 people engaged in that. They did speak to 30 people. Not all 30 people had comments to make that word derogatory.
Okay.
Just to be fair.
I can rephrase. So,
Yes, some made that allegation. Yes, ma'am.
okay. So out of the 30 witnesses interviewed, they reported that they had witnessed or had experienced, some of them, inappropriate touching committed by you. Is that fair to say?
Yeah, yes, ma'am. That's fair to say.
And some of the touching was that you touched some female residents on their waists, their backs, and their shoulders. Is that correct?
That's the allegation. Yes, ma'am.
Okay. And there were also allegations that you made several inappropriate comments that were sexual in nature. Is that correct?
That's the allegation. Yes, ma'am.
You would make comments about which female residents were quote unquote sexy.
Who were sexy? Sorry.
You had made comments that certain female residents were quote unquote sexy.
That was the allegation. Yes, ma'am.
Okay. You would state your preference for quote unquote well-endowed women.
That was the allegation. Yes, ma'am.
Okay. And you had made insensitive comments to lactating female residents about use of a lactation room to pump breast milk.
That's the allegation, yes, ma'am.
You also used work email, which was signed in your capacity as chief medical officer, to send over 100 emails involving pornographic content.
That's the allegation, yes, ma'am.
And just to be clear, these are allegations that are contained in the accusation, correct?
You're correct.
And you also sent emails containing racist, misogynist, and homophobic content. Is that correct?
That's the allegation, yes, ma'am.
And again, this is an allegation that is contained in the accusation, correct? Now, isn't it true that residents also raised allegations of discrimination based on gender and national origin perpetrated by you?
That's the allegation, yes, ma'am.
And this is an allegation that is contained in the accusation, correct?
Yes, ma'am.
Now, with respect to gender, there is an allegation that you prefer to select male residents over female residents.
That's the allegation.
And you did not allow female residents to care for patients with, for example, testicular torsion, and male residents to, for example, perform pap smears.
That's the allegation, yes, ma'am.
With respect to national origin, several residents alleged that you disfavored residents of Indian descent.
That's the allegation.
You told one Indian resident who was interviewed, quote, "I don't usually like Indians, but I don't have a problem with you," end quote.
That's the allegation, yes, ma'am.
And this is an allegation that is contained in the accusation, correct?
Correct.
You had made fun of these residents' accents.
Yes, ma'am, that's the allegation.
You assigned foreign-born or foreign-educated residents heavier workloads and more shifts.
That's the allegation, yes, ma'am.
And there were also allegations of a hostile work environment. Is that correct?
That's the allegation, yes, ma'am.
You had called people fat, ugly, lazy, and dumb.
That's the allegation, yes, ma'am.
And several residents reported that they felt verbally abused by you.
That's the allegation.
Now, moving on to some of the final accusations, isn't it true that residents also raised allegations that you misused your position on the board to intimidate them into not complaining?
That was the allegation.
Now, when residents complained about your inappropriate treatment, you told residents, quote, "I'm on the licensing board. Do not forget that," end quote.
That's the allegation, yes, ma'am.
And this allegation is contained in the accusation.
Yes, ma'am, it is.
Now, you also told them that you, quote, knew people and could prevent them from obtaining their licenses.
That's the allegation, yes, ma'am.
Now, finally, as a medical consultant, isn't it true that you had failed to disclose conflicts of interest to the board?
That's the allegation, yes, ma'am.
As a medical consultant, you were assigned to complaints against two physicians that were employed by Chino Valley Medical Center, correct?
That is correct.
And this is the same place where you worked.
Yes, ma'am.
You knew the physicians who were subject of the complaints, correct? You knew the complainants and everyone involved, correct?
I did.
And you never declared this to the board.
That's the allegation.
And in fact, these cases were closed without further investigation and without merit, correct?
That's the allegation, yes, ma'am.
Now, I want to shift gears a little bit and look to the efforts you took to rehabilitate yourself.
Thank you.
You completed an ethics and professionalism course from August 26th through the 27th of 2023. Is that correct?
Yes, ma'am.
And this course was 22 hours long.
Yes, ma'am.
Now, I want to make sure I understand this correctly. This was a 22-hour course completed over the course of 2 days. Is that fair to say?
It was 3 days.
Okay.
They were structured out as all-day attendance. And they're the ones that provided the certificate after I got approval from my probation officer.
Okay. So was it not from August 26th through 27th, or was it some other time frame, if you recall?
Ma'am, what you have written is probably what was done.
Okay. And then turning to the other course that you completed a civility and communication course from January 5th through the 7th of 2024. Is that correct?
Yes, ma'am.
And this is a 3-day course.
Yes, ma'am.
And this course was 30 hours long.
Yes, ma'am.
So this was a 30-hour course that was completed over a 3-day period. Is that fair to say?
Yes, ma'am.
And in addition to these 2 courses, you completed your continuing medical education courses, correct?
I have.
And were these mandatory, or were there some, I guess, additional CMEs that you took?
I take CMEs every month, so I would just continue to take them and provide them to my officer.
Do you know approximately how many CMEs you took?
I believe it's in the record that was provided by the board in his summary of my interactions with him.
And you also, in addition, as part of your probation, you provided quarterly reports to probation as part of the requirements of your probation, correct?
Yes, ma'am.
And you also volunteered?
I volunteer. I apologize.
Did you do some volunteer work throughout the course of your probation?
Yes, ma'am. I do volunteer.
Okay. In addition to what we have discussed in terms of your rehabilitation, so the courses you took, the CMEs, the quarterly reports submitted to probation, and your volunteer work, is there anything else that you have done to rehabilitate yourself that you can inform the Attorney General's office and the board?
Thank you, ma'am. I have. I've totally stayed away from the hospital environment. I've disengaged from the person that was the owner of the system that I worked for. And I've come to rely more on my wife, who's a lot smarter than I ever thought she was. But that aside, I focus my time on my 5-year-old twins, and I go home every day at a decent time, and I have my weekends free. So I think I've made a healthier lifestyle change for myself, which I think has been important. I've stayed engaged in and realized how important it is to be an ethical leader in my involvement with the American Osteopathic Association. And I actually, because of some of this, came about the fact that I put together a program called Safeguarding and Emotional Stability for the International Olympic Committee that I now lecture on for them. So I feel that it's been very, very helpful for me to have made those changes and to have detached myself from, as you pointed out earlier, a toxic work environment.
Sitting here today, do you take responsibility for the allegations that are raised against you and the accusation?
I hear the allegations that were made against me, and I have worked with them. I certainly do anything above anything to make sure that no one ever has that impression that I've either said something wrong or that I violated their space or that I've made a derogatory remark or action toward them.
Thank you, Dr. Lally. I have no further questions.
Thank you, ma'am.
Do any of the board members have any questions? It's fine.
No, I have no questions.
Thank you, ma'am.
Any other board members here, indicate to me if you have a question and I can ask you to identify yourself and ask it, including our member who's on video. Anybody else?
Your Honor, I have a question.
Please identify yourself for the reporter and ask it.
Himesh Patel here, board member. Dr. Lally, you mentioned that you stayed away from the hospital environment. The allegations against you are pretty egregious and concerning, and our mission is not to relitigate this matter, but to really ensure that the public is protected moving forward. how can we ensure that the public will be protected moving forward? And by public, I mean the future generation of medical professionals, every member that you communicate with. How can we ensure that?
Thank you, Dr. Patel. May I respond, ma'am?
Please.
You bring up a good point. I did separate from an area that I feel, as I look back now, was probably taking more of my common sense than it needed to because I was so engaged in being there 24/7, 7 days a week. It all becomes all encompassing, consuming. In the environment that I am now with a very supportive wife, I don't know how many times I'm going to say that, but she keeps me grounded. But more importantly, I did listen to this. I mean, if there's allegations, there's somebody's perception that I've done something that they didn't like. So with that in mind, as I do work forward and I do engage people, because I still interact with students that they were never taken from me, and I still interact with physician assistants and nurse practitioners, and we seem to have a very collegial relationships. I don't have a third party interpreting for me or telling people what they should say or do. So I think that the environment I put myself in has been very, very conducive for me to stay out of trouble and never to litigate this again. No chance. Thank you for asking.
Any other questions from any members of the board?
I'd just like to make a comment.
Please identify yourself for the
sorry,
reporter and then.
Brett Lockman, DO, member of the board. Earlier you said, in almost in an apologetic way, that you had a military background, and I just want to commend you and also to state that you should never have to apologize to anyone for having a military background in the United States of America. And if someone can't handle your military background, maybe they should drop and give you 20. Just put it there.
Thanks, sir.
Any other questions from any members of the board?
Matthew Swain, DO, member of the board. I just want to make sure that I understand your position about the toxic working environment in when you were there. Yeah, because I believe you were the program director, but also the chief medical officer.
I was, sir.
Who owns culture and respect in a medical organization? What medical leader does that?
That's very good, Dr. Swain. Thank you. I would tell you, generally, it is the chief medical officer who gets to dictate that. However, when your owner is a physician and feels very compelled and empowered to tell you how to do things, and then you choose not to, he does it himself. It becomes very much, that's why I left. After 18 years, I chose to leave because I felt that it wasn't beneficial. But you are correct. I controlled the culture and the atmosphere until I made the transition in 16. I didn't get out in time is what happened.
Any other questions from any members of the board? All right, seeing none. Is there anything else you'd like to say, Dr. Lally, to follow up on any of the questions that Ms. Ahmad or the board members asked you?
Thank you, Your Honor. I would like to just, because I wouldn't, this has been a humbling and valuable opportunity for me to learn. I had many shortcomings that I wasn't aware of and to make some changes. I think the important thing is that I've learned that with the communication, no matter how much we talk about it, if it's not being heard, then you need to change the style of what you do. Dr. Locke pointed out that I was being apologetic for being a military. No, I apologize if it sounded like that, but I just know that some people don't do well with the regimentation and the structure that I had in place. And I start to see that as it got on later in the years. And so I felt it was time for me to leave. So I made the motion to leave in 16. It was met with a lot of resistance. As the good DA pointed out, the residents that were complaining were people I had never interviewed. I had already moved back into an administrative position. But I respect this board. I understand this board. The challenge you have to keep everyone safe is and for that, I apologize for ever being on this side of the table, but provided and given that you allow me this early termination, I'm just going to take that forward to show everyone the system does work and it can be taken care of, because I'm still proud to be a DO and very, very happy to be in the position I am. So thank you, ma'am, for your honor.
Well, let me ask this question. Did you intend to present any other witnesses' testimony here this morning?
Oh, no, Your Honor, I was not.
All right.
Thank you.
Ms. Ahmad, is there any other rebuttal evidence that you'd like to present?
No, Your Honor, thank you.
Then before we conclude, I will invite summaries. Dr. Lally, you've given us a bit of a summary. Is there anything else you'd like to say to kind of wrap up your position and articulate for the board why you believe that your probation should end?
I want it to end, but I understand that that's a decision that is to the board. I will continue to work and represent the profession as best I can. I would like to, if I could, if it's appropriate, would like to thank the ONBC, the actual administrative side. They've been very, very proactive and helpful. They're a good source. Things have changed over time with the leadership within that office, and Ms. Calderon has done an excellent job, as has my probation officer, Mr. Carrillo. So thank you.
Thank you. Ms. Ahmad, what would you like to say in summary about this petition?
Yes, thank you, Your Honor. The factors that we must consider here today and what must be the guideposts for this case is we must weigh the severity of the underlying conduct as weighed against the need for public protection. So I'd like to point out here that the penalty that the petitioner received 2 years ago was incredibly lenient considering the severity of the underlying allegations. They're extremely serious. They involve sexual harassment, discrimination, misuse of authority, and creation of a hostile work environment. Sitting here today, the Attorney General's office appreciates that Dr. Lally has grown from this experience. With all due respect, however, the first step at rehabilitation is accepting responsibility. And I think the record speaks for itself in terms of my cross-examination of Dr. Lally and asking him about several of the accusations contained in the accusation, which are deemed here today to be true and fully admitted and correct. It appears that Dr. Lally is still having trouble accepting responsibility for his part in creation of the hostile work environment at this hospital. His position was supposed to be teaching residents. It was supposed to be a positive learning environment. And in effect, residents felt silenced. They felt intimidated. They felt they could not report Dr. Lally. And this has a direct impact on patient care. When you have a teaching hospital and residents who are trying to learn how to become good doctors, that has a direct correlation to patient care. If you are scared to report to a supervisor or you're scared of a supervisor and you have questions that are related to patients, that has a direct impact on the patient population, and the board must consider that impact. We commend Dr. Lally for the steps he has taken so far. We commend him for being compliant with his terms and conditions of probation. But 1 more year is only going to help the patient population. It's only going to help Dr. Lally continue to stay on this course, continue to make positive steps. And that is the Attorney General's position. This type of conduct was wholly inappropriate in a workplace setting. It's wholly inappropriate in a resident setting, in a teaching setting. And there were multiple violations of the Business and Professions Code, Section 2234. So keeping Dr. Lally on probation for 1 more year is in the best interests of public safety and the best interests of ensuring that Dr. Lally stays on a course of rehabilitation. Submitted.
Thank you. Dr. Lally? Sorry, Dr. Lally, you have the final word because you are the petitioner. Is there anything you'd like to say in reply?
Thank you, Your Honor. I understand the Attorney General's office perspective because they rely on documentation that's provided to them. As anyone in the medical field knows, accusations are made that way because the more horrific you can make them, the easier it is for the attorney to come after a physician. I would tell you that the accusations are the accusations. The stipulation was a settlement based on emotional tiredness on my part. The continuation of any process would have actually endangered any of the residents because they would have been called to testimony. And any of the residents that may have changed their minds or may not have agreed to the things that they had talked about would have been met with severe punishment by the owner at the time. So was I looking to protect them? Not necessarily, but I wasn't looking to prolong anyone's misery. So I do respectfully disagree with the Attorney General's office that I feel that I have learned my lesson and that I will be a productive member of this profession and continue to lead and grow, especially understanding that one, I'm under a microscope now. So I have to be careful about anything I say or do because people can run up the flagpole with it. But with that, I would, for my part, request that the board consider my commitment and dedication to the profession and my service, and that they do allow the I end a few months earlier than the Attorney General would like, just because I would like to free up my license and be totally free and clear. So when I do announce that I'm retiring, my license goes with me as it came in, free and clear. So thank you.
Thank you. All right, the board will take this matter under submission today. As I mentioned earlier, in connection with the earlier petition, the board will deliberate in closed session and produce then a written decision that you will receive sometime later. So thank you very much for your presentations. We'll go off the record.
Thank you.
And don't go away because I'm going to give you the same thing to explain how you'd order a transcript in the unlikely event you wish to do that. Great, thank you. All right, this is for you, sir.
Thank you, ma'am.
Okay.
Thank you, Dr. Box.
But am I excused?
You are, sir. Thank you. Is there anything else, Ms. Pines, then, that the board would like to do, anything on its agenda before it retires to a closed session to deliberate about these petitions?
No, we'll go into closed session followed by lunch and we'll return after lunch.
Okay, thank you.
All right, this is the moderator. I'm going to put the hearing room and then our online board member into a private room. And also Machiko. So let me go ahead and set that up. And then whenever you're ready, you can go ahead and start the closed session.
Okay. All right. Yeah. Okay. I want to welcome everyone back. We are going to go a little bit out of order, but before we do that, we're going to call the meeting to order and establish a quorum. And I ask that the board members unmute their microphones. And Machiko, can you please do the roll call?
Cora Damian,
Present.
John Cummins,
Present.
Brett Lockman,
Present.
Andrew Marino,
Present.
Amesh Patel,
Present.
Denise Pine,
Present.
Matthew Swain.
Present.
A quorum has been established.
Okay, great. So we have agenda item 6 and realize that our students are not going to be here until about 12:30. So we're going to move to agenda item 7, which is review and possible approval of the May 15th, 2025 board meetings. So I want to welcome Associate Governmental Program Analyst Beth Clark to the table to review the minutes with us. Is she here? Oh, she's virtual. Beth?
Yes, I'm here.
Okay. We're ready for you to review the minutes with us.
Okay. So I'm going to go page by page like I normally do, and just let me know if you need any corrections or edits, and then I'll turn it back over to Madam President Pines for a vote.
Okay,
so
thank you.
Start from page 1. Any edits? Page 2.
Excuse me, this is John Cummins.
I'm looking at agenda item 2, and I'm wondering if there's a typographical error. It's the board's mission statement is a little different. Actually, it says integrity and the safe practice of medicine by our osteopathic physicians. I think that's a typo, perhaps.
Okay, I'll check on that. Okay. Anything else on page 2? No. Page 3. Page 4. Page 5. Page 6. Page 7. Page 8. Page 9. Page 10. Page 11. Page
Excuse
12.
me.
Yeah.
This is John Cummins again. There's a reference, I think it's on page 11, to AB 489, a prohibition of AI. But the motion in support of that is actually, I think, misstated as motion to support AB 742.
And that was AB 489, you said?
Right.
Okay. I see it.
Yeah, page 11.
Okay. We'll get that corrected.
And I think and at the bottom of that same motion, there's also a reference to AB 742.
Yeah, I see
Which
that too.
I believe should be a reference to 489.
Page we'd have to.
Good catch.
Yeah. Okay.
Yeah.
Anything else on page 11? Page 12? Page 13? Page 14? Page 15? And page 16. Okay, I'll turn it back over to Madam President. Thank you.
Thank you. Can I get a motion to adopt the minutes as amended by the board members' recommendations?
Kamesh Patel here. I'll make a motion to adopt the minutes.
Can I get a second?
Second. John Cummins, seconds.
Are there any comments by members of the board?
Z. Penguin, board counsel, just to clarify, the motion was to accept the minutes with the recommendations by the board members.
Did I not say this?
Just the motion was.
Oh, the motion didn't say it.
Yeah.
Oh, okay.
You asked for the motion.
Yeah. You need to add that one. Okay. Yeah. Machiko, can we have a roll call?
Corey Damian,
Aye.
John Cummins,
Aye.
Dr. Lockman,
Present. Aye.
Andrew Marino,
Aye.
Dr. Patel,
Aye.
Denise Pines,
Aye.
Dr. Swain.
Aye.
Motion carried.
Great. Are there any public comments from members in the room on the minutes? Are there any moderator? Are there any public comments online?
This is the moderator for members of the public on WebEx. If you would like to make a public comment on this item, you can click the raise hand icon, or if you're an audio only participant, you can raise your hand by pressing *3 on your device. All right, and it appears there are no requests for public comment at this time.
Okay, great. The board minutes have been adopted as amended. Now we're going to move on to agenda item number 8, the president's report. This past fiscal year, the Osteopathic Medical Board of California has worked diligently to advance our mission of protecting consumers and strengthening the standards of care in our state. Throughout the year, regular and productive discussions with our executive director, Erica Calderon, have helped shape our meeting agendas and move important board projects forward. Looking ahead, Ms. Calderon and I have been discussing a Hill Day in January 2026. It would be scheduled for the day before our board meeting. We will meet with legislators to share an overview of what is a DO and to build support for a future bill to determine who is a licensed DO and protect our name. I encourage you to let me or Ms. Calderon know your availability to participate next January. We'll host another interested parties meeting to engage the public directly. And as you know, I sit on the Federation of State Medical Boards and termed FSMB, so I'll repeatedly say that. FSMB has recently convened a work group on trends in prescribing and dispensing. It's focusing on the rapid growth of IV hydration clinics, ketamine clinics, and other similar practices, which are topics of particular concern to our boards. The Ethics Committee and Professionalism Committee is also examining the role of physician unions and their possible intersections with state medical boards and regulatory oversight. The FSMB is closely monitoring developments at the federal level with regards to telemedicine and license portability, both of which are expanding quickly across the country and may require us to take a formal position in the near future. Regulation of artificial intelligence remains another important area as advances in accuracy and reasoning continue. FSMB has launched an Office of AI Innovation to help state boards improve efficiency in this emerging space. And finally, in an effort to inform the public about medical boards, FSMB launched a digital campaign. It's a $1 million campaign in June with 3 videos. To date, these 3 videos have over 7 million people have viewed them, and it leads them to a website called carematters.org for more information about medical boards. And when you land there, depending on where you live, it will pop up. If you're in California, it will pop up the California medical boards, and you can click and learn more about our boards. On September 3rd, I will be in Dublin, Ireland, speaking at the International Association of Medical Regulatory Authorities at the annual meeting. As part of the Cultural Safety Working Group, I'll be presenting the world's first guidance for developing medical regulatory standards to address medical racism and other forms of discrimination. And then later this month, on September 25th, I will be speaking at the Congressional Black Caucus Legislative Meeting on menopause and healthcare disparities, continuing our commitment to addressing equity in healthcare. And that concludes my president's report. Are there any questions or comments from board members? Are there any comments from members of the public in the room? Moderator, are there any comments from the public online?
This is the moderator for members of the public on WebEx. If you would like to make a comment on this item, please click the raise hand icon, or if you're an audio only participant, you can raise your hand by pressing *3 on your device. All right, and it appears there are no requests for public comment at this time.
Okay, perfect. We are going to move to agenda item number 9, board member communication with interested parties. Have any board members have anything they need to report or comment at this point? No? Okay. Are there any comments from members of the public in the room? Any comments, moderator, from the public online?
This is the moderator for members of the public on WebEx. If you would like to make a public comment on this item, please click the raise hand icon, or if you're an audio only participant, you can raise your hand by pressing *3 on your device.
Yeah.
All right. It appears there are no requests for public comment on WebEx.
Okay. This is, you're looking to make a public comment on agenda item number 8.
We're part of the student body, and we wanted just to ask questions. Is
Okay.
this the correct time, or?
I'm going to make the correct time in a moment. Okay. Okay, so we're going to move to this agenda item. Sure. You know what I have you do is read the mission of the board. Okay. I want to thank our students for joining us today. We're very excited to have you here. We are going to now officially go back to agenda item number 6, which is the Osteopathic Physician and Surgeon Student Question and Answer Forum. So I think this is a good opportunity for you to learn about the board, to ask questions that are your burning desire. I always say when you have an opportunity to be in the right room with the right people, is ask the questions you can't Google. So I want to welcome our Toro students. And if you can introduce both of yourselves, tell us what phase of school you're in, and if you're studying, what you're studying in particular.
Thank you, board members, for being here with us today. My name is Chris. I am the College of Medicine Student Government President, and here we have David. Go ahead.
Hi, everyone. Thank you all for being here today. I am David. I'm also on the student governing body, and I'm glad that to be here today.
Great. Thank you. Welcome.
Yeah, we're both second years, and we had prepared some questions and hope to get some insight from you all. Our first question is, we are aware that OMBC works to ensure safe practice of medicine by DOs, and as certified human beings, we undoubtedly make mistakes, even as physicians. From your point of view, how should we approach mistakes as future DOs? Not only to uphold patient safety and professional standards, but also to learn and grow from them in keeping with the osteopathic philosophy.
Okay, before someone answers that, I'm just going to have Ms. Calderon read the board's mission statement.
Thank you, Ms. Pines. The mission of the Osteopathic Medical Board of California is to protect the public by requiring competency, accountability, and integrity in the safe practice of medicine by our osteopathic physicians and surgeons.
So do we have a board member who's boldly going to answer that question presented by the student?
Himesh Patel here. I'm also a DO, went to Western. So thank you for the thoughtful question. As Executive Director Calderon stated, the sincere mission of this board is to protect the public. That's our goal. And the public includes you too. It includes doctors as well. It includes the patients that we see. It includes all the citizens of California. So our duty is to protect the public. And how do we stay out of trouble? That's the biggest conundrum. How do we avoid mistakes? It's going to be prevention and really knowledge about what can get you into trouble. Not doing anything egregious when you start to practice medicine. Because when you start to practice medicine, you have a responsibility to do the best you can and practice within the standard of care. And as long as you're practicing within the standard of care, you should be good.
My name is Matthew Swain, board member, and I'm also a residency program director. So I do a lot of advising and mentoring for growing physicians. And the things that I think will keep you out of trouble is humility. And I want to reflect back what you said, David, about as certified human beings, we could make mistakes. That is the most important thing for you to keep in mind. And when you're feeling the urge to hide something or to explain it away, that's probably a warning sign that you should ask, call a friend, right? We keep each other on the straight and narrow. And if you put the patient first and you're humble enough to seek, to look up things you think you know and talk to people, then I think that's 80% of it right there.
Brett Lockman, also DO, Michigan State. You're going to make mistakes. So if you do, own up to it, go to the patient, call your team meetings, call your safety meetings, do root cause analysis, share that. That's just a given. And hopefully you won't make many mistakes on your own sort of through just any sort of intrinsic failing on your own part. Usually mistakes are from the system, too much bandwidth required to do your job. So one of the best ways, if you do make a mistake, just own up to it and fix it. Hopefully you didn't amputate the wrong leg or what have you, because then they still need the bad leg amputated after that. But you're going to, especially in the modern world of AI and whatnot, you're going to have a lot of forces raining down on you where people, maybe physicians, but often not, are going to want you to forsake your role as captain of that ship. They're going to direct you. They're going to want you to see volume of patients. They're going to want you to subordinate the authority that your license gives you to help the machine run. But don't lose your humanity. Always put the patient first. And if that means you see fewer patients or you need more time or you simply have to buck the system only stays with the physician in charge so long as you have the courage to plant that flag and not allow people to control your license. You have to do that. And that takes courage. And you're going to take some bumps along the way, and so be it. Just do not let anyone take control of the authority that the board, through your licensure, has bestowed upon you because of the training that only you got. The CPA, the CFO, the nursing supervisor, the hospital manager, the CEO of the hospital, they didn't get your training. So the buck has to stop with you. When the patients come to see the doctor, they don't come to see the billing machine or the president of the hospital. They are there because they want your care, and that's where your duty lies. That's being eroded on a regular basis. The way it should work, you're there to serve the patient, and the system of patient care should be there technically to serve you so that you can do what you need to. Right now, more and more, you're expected to serve the system. But at the end of the day, that doctor-patient relationship should be sacrosanct, and just don't let people tread on it. But you're going to take lumps along the way for taking that stand. And you just take them. If that means you move on, you move on.
Okay. You have another question for us?
Yes, this is David, OMS2. So we know that DO can mean a lot of different things in the US and internationally. So from the OMBC's perspective, how can we as students ensure that our role as, future physicians is recognized and also protected?
I'd like to answer that if I may. So I'm also a board member on the Osteopathic Physicians and Surgeons of California. That is your professional organization as opposed to the state regulatory organization, which is what the Osteopathic Medical Board is. But your professional association that specifically speaks to osteopathic practice of medicine in California is the OPSC. One of the most important ways that you can make sure that your viewpoint and your practice is protected, join your organization, be a part of it. You have an amazing opportunity to guide legislators and helping them make decisions about our shared practice in the state, but only if there's an old saying that says, if you're not at the table, you're on the menu. Be at the table, join your professional practice associations.
Any other?
Yeah, I agree. Get involved. There's a lot going on in the community. There's the Osteopathic International Alliance. Denise, like she mentioned, she's going to IAMRA in Dublin. I'm going to go too. It's the International Association for Medical Regulators, something with an A. I don't know what the A stands for, but being present and having a seat at the table is what, I'm inspired by. And so I think that, getting involved is important. I'm sure, some of these organizations like the Osteopathic International Alliance have student, opportunities to get involved. More and more countries are recognizing DOs as DOs are what we do here versus, so the future is bright. And, I don't know if you know Dr. John Gimple, he's really involved in this too. And it's very promising.
Yeah. Okay, we're going to have Ms. Calderon respond on the
I want to add a little on the regulatory side, get involved with your board as well. Just making the first step of coming today and speaking to us is great. I know this board has wanted student participation, so we thank you for being here today and asking the right questions. On our board website, we have a lot of information. Know your laws and regulations so that you can stay out of trouble. We have a lot of frequently asked questions on what to do. And if you encounter certain situations, we also have social media accounts. I know that it's, not as frequently used nowadays from students, especially with your busy schedules, but we do post a lot of material on there. And it's a great content. Whenever laws change, we have regulations that go through, we post that material there. So just staying informed. We also have our newsletter. So if you like to read about what the board's doing, that's another tool to utilize.
On on a sort of big picture, real inclusive, real world level, language matters. So do consistently elucidate to the world how you are different and arguably better. I call DOs MD plus. You learn all the same stuff, but then you learn all this other great stuff. And then on a practical matter, learn that great stuff and keep using it. You're about to go out into clinicals. If you really want the world to embrace what osteopathic medicine has to offer, you got to demonstrate it. I cannot imagine how I would practice medicine not being a DO. Even if I'm not doing manipulation, I'm pain management and sports and a bunch of other stuff. But even if I'm not doing manipulation on my patients, I'm still using that osteopathic structural exam and gait analysis and seeing how they walk through the door, looking at their postural decompensation, how to fix all this stuff before I've even talked to them. And that will set you apart from all the other folks who are just going to throw pills and lab work at them. But in terms of language, specify the difference between osteopathic medicine versus osteopathic manipulation. Anyone can be taught how to crack a back, but where are you putting that in the context of the whole patient's picture? If you constantly have to adjust their T7 vertebrae, maybe it's postural, maybe it's esophageal cancer. And you can, if you think that way, you'll pick up stuff And anyway, you'll be able to offer something very unique to the world. And if you're in your second year, time is running out to have the time to the luxury to learn all that. So do it.
Hi, I'm Chris, OMS2. I do have a follow-up question. I apologize ahead of time for any lack of knowledge about this, but does the OMBC also provide licensure or accreditation to international DO physician, or I shouldn't say physicians, but osteopathics or osteopaths that practice in the United States that may or may not be physicians?
At this time, we do not. So in order to obtain a license here in the state of California, you had to have completed your training at a COCA-approved school within the United States. There are some programs that offer immigrant programs, which are like 3+ years, but it has to be completed here in the United States in order to obtain licensure.
Thank you.
Thank you, Chris and David. We have 2 new students coming up. Please introduce yourself. Let us know what year in school and your specialty if you have one.
Hi, my name is Dara, she, her. I'm an OMS 2.
Arnold Kim, him, also OMS 2.
And I had maybe a more bigger picture question. I think it's on top of a lot of the student body's minds, and in general for osteopathic students in California, there's a lot of shifts in regulations and laws, from the federal level and the state level. And I know that that has also been a topic of discussion. So from your professional standpoint too, when looking at us young up and coming physicians, what should we be most concerned about, and any possible solutions to mitigate any extra regulation or contradictions to the osteopathic philosophy and like the goals of the board going forward?
Good question. Doctors?
Well, I could help explain and tease apart, why do we have a state board? Why isn't it a national board? It's actually written in the Constitution that, each state has the authority to protect its public, which means that each state has their own board. And that's why you see a lot of variance in different policy and different positions and different regulations state by state. So that I don't know if I answered your question, but just kind of understanding that first is really important. But no, I think our profession is here to stay. I don't think it's under threat. And we have a pretty robust board. We have a whole series of boards in other states too. Some states have a combined board. Some states will have a mandate that a few DOs have to be on the board if it's combined. So I think that again the future is bright and has improved dramatically since I was a student. So this is a good time to be a DO.
Yeah, I would say just on the federal level, what I see is definitely DOs are growing. The spaces, there are more colleges being built around the country. There are more people looking for the sort of DO perspective and how you approach health, more of that 360 approach. So those are the things that I see on the federal national level. I do see there are starting to be consolidations of the DO board and the medical board, but it's not trying to separate what DOs are in their specialty. So it's not a separation. It's just more of, I think, a bandwidth from a staff standpoint. In our state, I don't see that happening at all. So if you're going to practice in California, you'll be fine here.
Dara, can I ask you to give examples of the increased laws and regulation that you mentioned? I'm not sure I track.
Yeah, I think I'm just thinking about the shifting policy landscape, like federally, when thinking about public health overall to me, and perhaps to OMBC, We see osteopaths and physicians in general as public health professionals. And so we're seeing a lot of shifts in the systems that are put in place to protect the public health of California or the country as a whole. If we're thinking about health regulation and scope and ability for physicians to practice, of course, this is a different state by state level. But even when we're thinking about different laws that, are federal, that are trickling down to the state level that affect the resources that students have to be medical students and continue being medical students. When we're thinking about, our federal loan programs, and these are a wide variety of different policies and systems. And I think my main point is that it seems like there's a lot of change right now, and a lot of change that puts a lot of labor on students that are unsure about what the future looks like. And I think we have, it's such a wonderful opportunity that everyone is here and able to give us some insight on how we should look forward and remain hopeful in light of all of these things that are pressuring us in different ways.
I'm still unclear about the specific laws you're talking about. Sorry.
There's a lot. The younger generations are a lot savvier, I think, than we were. They know about the fact that medical student debt is a huge issue and it can be $400,000. And there's now new laws saying that we won't lend you more than $275.
Is that what you're getting at?
Everything.
Definitely one of them.
There's things like impacts of like the big beautiful bill on health funding for like FQHCs. There's a great deal afoot right now. There's a lot of fear and insecurity. Do what you're doing. Lead from the front. Be an advocate. Go to your DO Day on the Hill. Go to your OMBC meetings. Join your professional association. Get your voice out there saying, we are here to take care of people. Keep it outside of politics and focus on the patient, just like anything else. The patient is number one. And we'll get through this. Don't get scared. When we go to fear and anger and we get a scarcity mentality, it is easy to lose hope. But there is nothing new under the sun. We have been here before. We're gonna fix this, but we gotta band together. All the Cheerios in the bowl need to stick together, and we'll make it better. I don't know if that's helpful.
Yeah, that's helpful. And yeah, to be clear, of course, there's a lot of shifts in, how physicians can practice, differences in how Medi-Cal and Medicaid reimbursement works. California specifically, of course, is approaching a budget shortfall. And so there's a lot of concerns there. There's a lot of bills on the docket, affecting how osteopathic physicians and also different healthcare professionals can practice and their scope of practice. And so I think there's just a lot, of course, and you all are, as the body, really knowledgeable about all of that. And I think for students to be able to parse through that and then understand, okay, that there is a plan and a path forward that protects us and our patients is really valuable to hear and understand. So thank you.
If I can add to your comment, part of what we talk about at some of these board meetings is legislation. We have a whole agenda item on that, and we have a whole person at our board and staff member who reports on what impacts your profession specifically, and that's part of our topic. So just going forward, I wanted to point that out so that you can listen in at some of these board meetings, because we get into the detail and you can see how your board members take positions on these bills. And you can see where the regulatory body is going forward with those, proposed changes that are coming forward. It's every season, usually January, if I'm correct. That's the board meeting that we give the rundown and take positions on each specific bill that particularly impacts your profession.
Thank you. Thank you so much.
I think, and I'm sometimes critical of my brethren because, to get into medical school, you had to be at sort of the far right end of the bell curve. And then when you get into medical school, the bell curve is like a spike. Everyone was an A student, everyone was a high performer, et cetera, et cetera. And then you do your internship and residency and maybe fellowships or what have you. And then you think, I made it. And I see a lot of docs who think I've made it and now I'm done. And they want some sort of guarantee thereafter where they don't have to keep swinging. You always have to keep swinging. It's never going to be, oh, I can just go to my work and treat patients in this sort of idyllic political set. There's always someone who's going to try to get what you've got and take it from you, take away your authority, take away your access to do what you need. And you just always have to be that A student, and you always have to try. And if you just think, you know, I want my 50-hour week or whatever and smooth sailing, more, you get more certifications, be politically active. You always have to keep fighting. You never, if you don't stay on the end of that, right end of that bell curve, someone will take it from you. It's like you're living on the savannah. You don't get to sit around and enjoy the sun. Someone's going to eat you.
Got it. So the rat race really never
It
ends.
never ends. And I see docs who are like, I just want to go to work. And I'm like, dude, suck it up, fight.
Yeah. And another question about that, for me, like, how can we best advocate for, incentives, like to incentivize physicians to have the space and capacity to continue that fight between, of course, we have, on average, more medical school debt. The medical school student population is diversifying. We're from more different walks of life than we used to be. And so that also comes with different responsibilities and different, mostly financial burdens, to be able to move forward in society and your typical, day to day that maybe we were used to or expecting when we started school. And so how can we best advocate for those incentives, whether that's loan forgiveness, whether that's, and just because we have students here now that we're out of class, if there's any specific bills or advocacy pieces that you all would like to highlight from those sessions as well.
So again, I'm active both on our regulatory authority in the state of California, which is the Osteopathic Medical Board, but I'm also on the Osteopathic Physicians and Surgeons of California, which is the California membership group under the AOA. I just got back from the AOA House of Delegates. Have you heard about that? That is how DOs get their voice heard in legislative bodies around the country, including, and we have full-time lobbyists that make sure that our positions are understood and that our patients need, more importantly, that our patients' needs are understood by people making these decisions who due to no fault of their own, may not really be able to make an informed decision. So if you want to be heard, get involved, get in COSGP, get in, I don't know if I said the acronym right, but get involved in any way you can in leadership. You don't need a title. You just need to show up and support efforts to educate decision makers or become a decision maker. Is that helpful?
Yeah. And just, as like student government members too, we're always looking for ways to bring this information back to students and to really show them the really tangible things that you all are doing and that we can do to support it. So exactly like you said, Dr. Swain. And if there is any, specific bill or, lobbying point right now that you deem, and anybody on the board that you deem that is most important or one of the most important that we should be paying attention to as medical students and really throwing ourselves behind, not just our OPSC chapter or not just any of the advocacy or government chapters at our school, what would that be?
Sorry if I'm talking too much, shut me up. But so I'm really passionate about all this stuff, and it's hard for me to break this down and give you individual tasks that you can do here today. But what you're doing, you're already doing it. You're here. You're saying, I want to learn, because this is not something you do once. You do this throughout your educational and professional life. Okay. So be present, listen, learn, vote with your presence. You'd be amazed. You're going to learn a great deal about how laws that affect us get made if you participate every chance you get in professional organizations, whether you're as a student or as and it is hard. It is hard when you're a student. You're worried about, passing your COMLEX 2. You're not worried. You're not thinking about, you guys are a credit to be thinking ahead. Okay. But keep in mind, learn. You never know when you're going to get a chance. But if anybody offers you a chance, somebody says, do you want to go to DO Day on the Hill? Yeah, heck yeah, I do. Do you want to go to the House of Delegates? Heck yeah. Okay, this is how you make a difference.
Also, you seem to be sort of a mixed thing. We're focusing on legislation that might negatively impact the future of your career and earning potential and being able to pay back loans. And that's one whole side of the house. The other side of the house, which a lot of doctors are absolutely miserable at, is do you have your financial house in order outside of medicine? Be financially savvy. Speaking from personal experience and hundreds upon hundreds, maybe million at this point, dollars lost, do not put personal guarantees on most things in life. As a rule, if it says, I personally guarantee this, just refuse to sign that or negotiate that out. You're not gonna be able to do that with a house, a new car, but anything else, any kind of loans, you want that construction loan for a new clinic, go to a lawyer, always get construction insurance on anything you're gonna buy. Do not think, oh, it's not gonna happen to me. It will happen, trust me. And have a financial life separate from medicine. Who knows? We might take away your license. Have enough reserve capacity that you can flip the bird to the world and still survive for a year. And that starts by just talking to financial advisors. Don't take the word of bankers. They're in it for themselves, not you. Yeah, just that's separate from the legislative part. But if you owe $400,000 in loans, and then you accidentally are texting and run over someone in the crosswalk and get hit with a negligent driving lawsuit, and they take away your house, and good luck practicing medicine with a stress-free life, because it's just not going to happen. So keep your finances in order.
To that point, when very soon you're going to be interviewing for residencies or doing sub-Is, auditioning, ask questions in your didactics in your residency. Do you cover how to negotiate your first contract? Do you teach us anything about financial management, about covering ourselves for disability, about, you can't, there's only so much of your academic time you can spend on non-core subjects, but a program that cares about your development as a whole physician is going to include some of that. Ask specifically, what are you going to help me do to prepare for my life when I graduate residency? Very important stuff.
Get umbrella insurance.
Yeah.
If someone says this is the standard language in the contract, everybody signs it. Get your red pen out. If they refuse to negotiate, walk. Walk. Don't worry about their feelings. Walk.
Okay. Arthur, do you have a question?
I do. Sorry to pivot from this beautiful discourse that we're having. It's also thank you for being here for us. Dr. Swain and President Pines, you kind of mentioned this earlier, which is perfect for my question. Osteopathy in the US continues to grow. In fact, our class, Arturo, starting with our class, we had an increase in student size. I know there's a new DO school opening in Chicago. So it seems like we're going to be promoting osteopathy more. It seems that residencies or residency spots are still pretty limited. And so I know that OMBC works primarily with California licensure and such, but what is OMBC doing to advocate for more residency spots and to ensure that DO students like us have a fighting chance at the table when it comes to interviewing for residency?
Well, this was not addressed to me. I know, I heard last week that now COMLEX across the board for most specialties, I think, I'm not sure if it's emergency medicine, is now accepted as equivalent with USMLE, and you do not have to go out and also get the USMLE. A lot of DOs, to be competitive for those quote MD spots, had to also take the USMLE along with it because COMLEX was not considered the same, or some places have gone to pass fail on COMLEX and USMLE still had a score, so they didn't, it was like apples and oranges, but now it's for most, you have to check your specialties, but for most, I think it's now considered, there's equivalency.
I think I can add to your question by saying on the regulatory side, awareness, outreach is what we can focus on. And part of, what we do is also, educate our consumers of what professions are out there, right? And how to stay informed. And the more outreach that we can do about ourselves putting our profession out there and helping OPSC, helping the associations and getting the word out there. I believe if there's a trend of patients seeking more an osteopathic approach in their medicine choices, then demand will be there for more doctors, which will open up the gate for more residency programs to have more of your specialty type of profession, available to our patients. So on our side, what we're doing is putting the word out there and making sure that our patients know that we exist. Because to be honest, we get confused with the medical board all the time on the patient side as well. And so part of our efforts is outreach and starting at, going to health fairs and letting the public know that there is such a doctor out there and that they are fully equipped to treat you in all areas and all specialties. So on our side, that is our promise. On the regulatory side is to put our profession out there as much as possible to get the word out that our board exists and that we're here and that we'll continue to grow. We are growing tremendously. You'll hear, if you stick around, an update on licensing and you can see how much we're growing yearly. So the profession is here, it's here to stay, and it's going to continue to grow. And we just need to continue our outreach efforts on our side too.
So I heard sort of two questions in your question. One is, what about residency funding? How come we can't have more residency slots? That is a national political question. That is about CMS policy and how funding is allocated. And that's where, for example, being a member of OPSC, AOA, whatever, contributing to that national discussion. And when we say, when Congress says, well, we're looking at funding, do we need more residency slots? That's how you make your voice heard on that. Heck, yes, we need more residency slots. Okay. But I'm going to do something uncomfortable. I'm going to put this back on you now. Be a part of the solution. I never thought about going into GME. I just happened to stumble into this job almost by accident, and I love it. You are never going to have a better opportunity to learn and be a better physician than when you are teaching. Consider academic medicine as a part of, that's a possible career path. People, honestly, tend to think about running screaming away from residency when we're done, right? Just like school. But it's amazing the opportunities that are out there. If you want to see that grow, one of the biggest things is with any medical group, whether it's for teaching or anything else, is you got to have people show up and be willing to do the work. So if you want to expand that, a lot of programs fold because they can't get or maintain faculty. And it's a best kept secret. It's really a great thing. So get out there, Ask your attendings, hey, do you teach in the residency? Make them squirm. Well, why don't you teach in the residency? Didn't you weren't you a resident?
I just
So-
have one follow-up question before I hand over to my wonderful colleague here. About residencies and such. Are we seeing trends in general where we're having more osteopathic physicians in these leadership positions, for example, as residency directors, or if not, at least some sort of associate position to help make those changes and, be a part of that education? And if not, what can we do to make sure we get more representation in GME specifically, as you mentioned, Dr. Swain?
So we have very highly placed DOs in many national organizations now, including the ACGME, which runs all the residencies. So yes, is the short answer. And again, ask yourself what you're going to do about this. Ask your attendings gently, respectfully. Ask your attendings, hey, what are you doing about this? And they're probably going to go, but maybe they'll get involved too. So be active, be a passionate advocate for your profession and for your future.
I yield my time. Thank you.
Thank you. We're going to take one more question, and I think you have come up. Jump over.
Hi there. I'm Cameron Quill. I'm a second-year medical student. Thank you for your time. I wanted to ask a quick question about kind of strategies that work to protect the rights of DOs. We've heard that in some companies or medical groups, there's bylaws stating that you need to have an MD, a DO on the board. And as time goes on, it gets a little more lax, and now you have NPs and you have other providers. So what other strategies work to keep that voice in the room at like a kind of a corporate level from your perspective?
Strategies by who? By us or by you?
Well, I guess just things that have worked to keep the voice of DOs in the decision-making process at like at the corporate medicine level.
So Ms. Pines or Calderon could maybe speak to this, but we also, like just at the last May meeting, we were, I think, going over again, what was that January meeting regarding the use of the term or the abbreviation DO, the fight that we were putting forth to protect against foreign osteopaths who come into the US and hang out their shingle as an osteopath. And unfortunately, legislatively, we haven't won that yet because they technically are osteopaths in their country. And so, but they can't claim the title DO. Yeah, I'll just leave it at that.
There is going to be a bill that will be introduced hopefully next season. OPSC, the association, will be bringing that up. It is, on their side, mainly their role more so than the regulatory side. However, this board plans to support that, obviously. But at the level of keeping that word out there, I mean, title protection is huge, so that there's no other individual out here that also on the regulatory side gives the perception that they may be a physician in general, right? So that's one of our goals with that title protection. Your board up here is made of only DOs and public members. So part of those requirements also play out in the board session as well in the regulatory body. And I think in general, that's every board. They have their specific professional representatives plus the public being a representative alongside. That's what I can add on in terms of the regulatory sides.
Yeah, and at the national level of board representation, so the Federation of State Medical Boards has a significant number of DOs who are on that board. And that organization is a guiding organization. It's sort of more like a think tank looking at issues down the road. So DO voices are inclusive in the future thinking of where the professions are going. So to let you know that there are people thinking about the issue around residency. We recognize in the entire country, that there are at least 500 residency slots that are needed. And there are a lot of people looking at what can we do about this? How do we still utilize these doctors in ways where they can still practice and it can be effective, and it serves them in terms of practicing. It also serves the patients that they will be serving. So there are a lot of people thinking about this issue. This is not something that's out there and we know it, and we're just sort of bypassing our thought like, oh, it's just too bad they didn't get one. No, there's a lot of active conversation, and I think we will see something very effective within the next 2 years, because there are a lot of things on it. People are actually talking about this in significant ways where laws will be passed around it.
I'd like to actually provide just a little bit more detail. I mentioned that there are people in high leadership positions. I'm going to give you specifics. So on the ACGME, there is one of the top people in the board is the senior vice president who manages osteopathic accreditation. That's a DO. So in the very, very top of the Accreditation Council for Graduate Medical Education, which has all specialties, all GME in the country. And then separately, the CEO and president of the Federation of State Medical Boards, Dr. Chowdhury, is a DO. So we are well positioned and well represented in these big picture organizations. But what you asked was a better question. How do I affect that in my local medical staff? If I'm reading into your question. So how you do that? Vote with your feet, show up, be at the table. I'm going to say it again. If you are not at the table, you're on the menu. So what does that mean in practical terms for you? That means somebody asks you, will you be on the bylaws committee? Yes. Will you be on the professional practice committee? Yes. Okay, because if you don't, you can't complain about the decisions that get made about in your hospital or in your clinic system, right? If you're not contributing. So do that unpaid labor of love. I'm not saying you have to be the CMO, but show up and do the work to represent DOs in your practice.
And again, sort of to the last question as well, maintain that osteopathic distinctiveness. Bring to the table something that no one else, be it a NP, a PA, an MD, whomever, can bring to the table. You don't want to be simply equivalent to your MD counterparts. You want to bring something absolutely unique. And for most subspecialty or specialties or subspecialties, family practice, whatever, it can be significant. Maybe not pathology, maybe not radiology, probably less so in derm, but still, if you can bring something to to train their residents and make the MDs better too. If you can teach them whatever. I don't want to go into osteopathic manipulation, but the point is, set yourself apart in that regard. Also, to my previous point, everyone's going to be nipping at your heels. Sometimes it is sort of a zero-sum game. So the nurse practitioner lobby is ridiculous. They come out of the nursing lobby and they're powerful and they're looking at no one ever wants less power, less money, less control. Everyone always wants more. So you have to fight. And if you say, well, my diploma counts more, not to the legislators who had 20 people from the nurse practitioner lobby knocking on their door while you're sitting at home polishing your diploma frame. You got to get out there.
Okay. I want to thank all the Toro students, Chris, David, Arthur, Cameron, Amrish, I think that was her name. Thank you for coming today, for meeting with us, for sharing your concerns, for asking really great questions. Again, we have so much information on our website, and we do outreach at our schools. I know Toro is one of the schools that we have come to before. We really appreciate it, and we hope to see you next year when we come for a visit. So thank you.
Thank you.
May I just say that any medical student or resident or anybody can reach out to me. I'm not hard to find. I'm on LinkedIn. If you have questions, if you want mentoring, I'm paying it forward. I had fabulous mentors coming up. There was a lot of things I had to learn the hard way. I don't want that for you. So you got questions, you got concerns, reach out to me.
Likewise.
Great, perfect. Thank you. Thank you both.
Thank you.
So we're going to move now to agenda item number 10, Intergovernmental Relations Report and Administrative Services Update. We are joined by author Babakahan. He is the OIO manager, and I'm sure I probably butchered your last name. Author, are you here with us?
This is the moderator, Arthur. It looks like you're muted.
Oh.
Here you go. Can you hear me?
We can. You sound a little light. If you can move closer to your mic.
Hear me now? Or
This is the moderator. It still seems to be a little quiet. Do you have a headset, or maybe you can use the call-in option?
let me connect the headset real quick.
Okay, perfect. Thank you.
Okay, author, can you say something?
Is the
Okay, you're cutting in and out.
How about now? I think it just connected.
Okay, perfect.
Okay.
Please start.
Okay. Yeah. So good afternoon, everyone. I'm Arthur Babakanyan of California Department of Consumer Affairs. Just thank you for the opportunity to join you today. I have a few updates on my agenda, and we could get started with the governor's reorganization plan. So in January, Governor Newsom released his proposed 2025-2026 state budget, which included a proposal to split DCA's oversight agency, the Business Consumer Services and Housing Agency, into two state agencies, the California, so it's the California Housing and Homelessness Agency and the Business and Consumer Services Agency. After public hearings and review by the Little Hoover Commission and the legislature, I am pleased to share that the governor's reorganization plan was enacted on July 5th. Again, the new Business and Consumer Services Agency will be responsible for consumer affairs, licensing, and enforcement, and the Department of Consumer Affairs would be among the 8 departments in this new agency. The two new agencies will officially become operative on July 1st, 2026. DCA is participating in multiple agency work groups on the logistics required to transition to the new agency and will continue to keep the board and bureau leadership apprised throughout the year ahead. And then regarding hybrid telework transition, on March 3rd, 2025, Governor Newsom issued an executive order requiring all state agencies and departments to update their hybrid telework policies for employees and increase from 2 to 4 days in office per week beginning on July 1st, 2025. At the end of June, agreements with several labor unions representing employees within the Department of Consumer Affairs were released, delaying the 4-day in-office requirement by 1 year for most employees. As always, we appreciate staff's flexibility as the situation evolved. And then moving on to travel updates. On June 9th, 2025, the Department of Finance issued guidance for out-of-state travel in the upcoming fiscal year. Travel outside of California will be limited to essential travel that is required to conduct state business, meaning requests should be only made for mission-critical needs. DCA distributed a memo to all boards and bureaus on June 16, 2025, detailing the criteria for mission-critical travel, including but not limited to enforcement actions, revenue collection, statutory requirements, auditing, and litigation. Additionally, all requests must be provided to DCA's budget office 8 weeks in advance to allow for review by DCA agency and the governor's office. If there are any questions, please contact your assigned budget analyst at DCA. And then we would also like to remind board members and staff of our collective responsibility to always work to minimize the cost to the state through responsible travel planning and scheduling. To best serve the public, it is incumbent upon all of us to ensure that we are being fiscally prudent in our decisions, especially when traveling for board business. DCA is reminding members and staff to evaluate if a rental car is always necessary versus ride-sharing services. Carpooling is also highly encouraged when renting vehicles. We know that there may be new travel costs board members are experiencing as well, such as baggage charging, so please keep receipt to ensure that you can be reimbursed. If you have any questions, please reach out to the member relations so we may assist you. And then finally, the annual report. This is one of DCA's biggest projects. Staff work on this report throughout the year, gathering information and statistical data in order to compile a comprehensive report about the department's actions to submit to legislature. On behalf of the director, thank you to board staff for efforts and contributions. Published to the DCA website this summer, the annual report has a wealth of information and memorializes all the great work done by so many throughout the department. DCA encourages board members to take time to review it and use it as a resource. And that will conclude DCA's updates. Thank you for the opportunity to join you today. I am happy to answer any questions that you may have.
Thank you so much, Arthur. Are there any comments from members of the board? Are there any comments from members of the public in the room? Any comments, moderator online from the public?
This is the moderator for members of the public on WebEx. If you would like to make a public comment on this item, please click the raise hand icon, or if you're an audio only participant, you can raise your hand by pressing *3 on your device. All right, and it looks like we do have a request for public comment from Harley Macris. And Holly, you'll be given 3 minutes to speak with a 15-second warning. Please click the unmute me button when the prompt appears on your device.
I think I've done it. Can you hear me?
Yes, this is the moderator. We can hear you.
Thank you. Hi, everyone. Holly McChris, Executive Director of OPSC. Sorry I can't be in the room with you today. I'm so excited to have been hearing everything you've been doing. If I heard what was being discussed correctly, I just want to emphasize how wonderful and how important it has been to have OMBC staff and leaders at our meetings so that they can interact with the DO in person and updating them on what's happening. That's been very valuable. So whatever can happen to continue that relationship and allow them to be able to travel to our meetings is greatly appreciated.
Thank you. Are there any other comments online?
This is the moderator. It appears there are no further comments on WebEx.
Okay, great. We're going to move to our budgets office update, and we are joined by Kalia Van Lint in the DC Budgets Office. Kalia? Oh, you're muted. Okay, there you go.
Hello.
Yes.
Okay. Perfect. Thank you, Madam President Pines, and good afternoon. My name is Kayla Van Lint, and I am a budget analyst with the DCA Budget Office. I am joined by the budget manager, Nicole Dragu. I want to thank the board and the executive staff for allowing me a few minutes to present on agenda item 10B, the board's expenditure projections and fund condition statement. First, I'm going to start with the board's expenditures included in your materials. These projections are based on actual data through fiscal month 12. This report includes 2023 through 2024 actual expenditures in green, as well as 2024 through 2025 budgeted and projected expenditures in blue and orange. As we move to the end of the document, you will see the board has a beginning budget balance or beginning base budget of $4.41 million and is projected to spend about $4.33 million, creating a reversion to the board's fund of approximately $22,000, a reversion percentage of 0.52%. The next document I'll be going over is the board's revenue projections included in your material. It'll be slide number 2. This report includes receipts collected through June. I will go further into the projections as we transition to the next slide. This next document is the board's fund condition statement that is also included in your materials. As a reminder, we read this document from top to bottom and left to right. The left column is the board's prior year, 2024 through 2025, based on fiscal month 12's projections. Please keep in mind that once the fiscal year is reconciled in fiscal month 13, the projections may slightly vary. It shows the board began 2024 through 2025 with a beginning balance of $5.05 million. The board collected $3.9 million. Oh, I'm sorry. Did someone say so? Sorry about that. I think I was getting a little bit of feedback. To continue on, the board collected $3.9 million in revenues, with $1.03 million from initial license fees, $2.68 million from renewal fees, and $194,000 was collected from the issuance of citations, fines, delinquent fees, and other revenue. The board expended $4.34 million, which includes $242,000 in direct draws to the fund for statewide pro rata and pension payments. The board ended 2024 through 2025 with $4.61 million in reserve balance, or about 11.9 months in reserve. For current year 2025 through 2026, the board projected revenues of $3.98 million, with $1.51 million projected from initial licensing fees, about $2.26 million from renewal fees, and $214,000 from the issuance of citations, fines, delinquent fees, and other revenue. The budget office will continue to monitor the board's revenue and expenditures and report back to the board with monthly expenditure projections as we continue to close fiscal months in the prior year and the current fiscal years. A few things to note of the board's fund condition. The fund condition is a snapshot in time. One of the main factors driving expenditures increases in future years is a result of personal service adjustments. These include general salary increases, as well as employee compensation and retirement rate adjustments. The budget office includes a conservative ongoing 3% increase to expenditures on the fund condition statement to account for these ongoing incremental adjustments. You will also notice revenue is projected static in the out years. Lastly, I would like to note to the board that any future legislation or unanticipated events could result in the board's need for additional resources, which would create cost pressure on the fund. The budget office will continue to monitor the board's fund condition statement and keep the line of communication with the board's executive staff open for any future needs or expectations. Again, thank you for allowing me the opportunity to present at today's meeting, and we will be happy to answer any questions that you may have.
Sorry, any comments from board members? Any comments from members in the room? Any comments from members online?
This is the moderator for members of the public on WebEx. If you would like to make a public comment on this item, please click the raise hand icon, or if you're an audio only participant, you can raise your hand by pressing *3 on your device. All right, and this is the moderator. It seems there are no requests for public comment at this time.
Okay. Thank you again, Ms. Lent.
Thank
We are
you.
now going to move to agenda item number 11, Executive Director's Report presented by Erica Calderon.
Thank you, Ms. Pines. Good afternoon, Madam Board President Pines, Vice President Patel, Secretary Adamian, and members of the board. Before I get started with my report, I would like to take a moment to thank Touro University for hosting us today. Such a beautiful campus, and we just love coming back, whether it be for a board meeting or to host one of our professional identity lectures alongside Dr. Wagner and Dr. Ho. Given that we are at a school today, a lot of our students are starting school this week, and so I would like to take a moment to wish all of our wonderful students a wonderful school year, and particularly congratulate all of those that just underwent their white coat ceremonies. Now to the executive report. Just a reminder, this report is intended to provide the members of the Osteopathic Medical Board with an update on personnel and other administrative functions and projects occurring at the OMBC, and no action is needed. Would like to take a moment to announce that 2 of our board members just recently get reappointments this past quarter. The board is happy to announce the reappointment of 2 of our public board members, Gore Adamian and John Cummins. We thank you for your continued services on the board, and I personally look forward to working with you a lot more years to come. State budget and travel restrictions. I know that author kind of covered this topic already, but I'm going to go ahead and mention it again. OMBC is still operating under the Department of Finance's issued budget letters. OMBC must monitor overall expenses and limit our out-of-state travel to essential operational needs, which means that all of these requests, as author mentioned, must be approved by the governor's office, and approval will be limited to mission critical only. Mission critical, just to clarify, that's anything that's related to mainly enforcement, traveling for probation meetings, any federation of medical board can be considered critical. So it's going to be very discretionary in terms of what we can do for the next couple of a year. In terms of personnel, the OMBC continues to have 15.9 authorized positions. There is 1 vacant enforcement analyst position currently at the board, and there is another analyst who did recently go out on medical leave. The board has requested that we post immediately to backfill for our vacant enforcement analyst position, and requested a temporarily limited term position to cover the desk of the analyst on leave. At this moment, Machiko, if you can please share the organizational chart, just so that the board members can kind of get a visual of all of the changes and where we're structurally at. In June of 2025, OMBC did advertise for a special investigator position through its blanket authority and has made an offer. So I'm very happy to announce that Ms. Yvonne Nathad is scheduled to start with the board on Monday, September 8th, 2025. Ms. Nathad has over 15 years of enforcement experience, with the last 10 years being a special investigator for the Medical Board of California. The board hopes that with this position, the board can reduce investigative cost and also improve with complaint processing times, as it is projected that about 60% of overall field investigations can be handled in-house instead of utilizing the services of DFI. Along with this update, I would also like to point out that I am in the process of obtaining subpoena enforcement authority for the board. This will allow the board to request records through our administrative subpoena process in-house without having to go and get the assistance of DFI. In terms of Executive Order N-2225, the return to office order from Governor Newsom, as previously reported on March 3rd, 2025, Governor Newsom issued Executive Order N-2225, requiring all agencies and departments under his authority to implement a hybrid telework policy with a default minimum of 4 in-person workdays per week. Effective July 1st, 2025, the return to office has been postponed for an entire year to July 1st of 2026 through union negotiations. Just as a reminder, OMBC staff are coming into the office twice a week, and at this time, I have not identified a need to have anyone coming into the office more than what they are allocated at this moment, with the exception of our receptional desk, which is a full-time in-office position. In terms of the retention schedule and clarifications of what we previously reported as a purge project going on at the OMBC, on September 6, 2024, OMBC did a revision of its retention schedule to be more specific with all records across all programs, and most recently revised its schedule in July of 2025 to address 2 specific complaint closures for enforcement, which were previously not listed on the schedule. One being the non-jurisdictional closure, which has a retention of 1 year. And secondly, the board separated its quality of care, no violation closure involving patient death and no patient death. A quality of care, no violation complaint involving patient death will now have a retention of 5 years, allowing the board to reopen a case without having to recollect new records if new evidence is presented to the board and we still find that we have a statute of limitations that we can work with. At the last board meeting during the enforcement program update, the board reported that the office was working on a purge project. Questions and concerns were raised, and OMBC wishes to clarify that report. As previously reported in 2023, OMBC was sharing office space with the California Board of Naturopathic Medicine. During the years that both boards shared this office space, OMBC's organization did suffer, having one file room for both its licensing and enforcement files. Staff started to keep records in boxes, and it stopped purging records for several years to avoid any accidental purging. In addition, OMBC's retention schedule was very minimal, and board staff felt very uncomfortable purging anything. Thus, the board has an extensive number of records across all programs, not only enforcement, to purge. With CBNM having their own office now, OMBC has been working very diligently for the past 2 years on getting our office very organized, which includes the purging of records previously stated that had not been purged, and I can safely say for over 2 decades. At this moment, Machiko, if you can please bring up the retention schedule and just kind of briefly go through the pages. You can see that we have everything listed on there. It's broken up into sections: administrative, board records, and licensing records, and then enforcement. The next item that I'd like to talk about is OMBC's budget. I think this is a hot topic for us right now. Several questions have been asked by board members about our budget projections in the next couple of fiscal years, specifically about our months in reserves decreasing. OMBC would like to address those concerns and address what I have been working on in particular to increase our board's revenue and address our expenditures. Over the past 2 years, OMBC's budget has been impacted by the additional leadership positions and staff positions, but most significantly because of its increase in consumer complaints, which have resulted in more disciplinary action taken by its enforcement program. In addition to an increase in staffing levels, OMBC did do a permanent AG augmentation, and just this past quarter requested an augmentation in its expenditure authority for its Office of Administrative Hearing Cost. In addition to AG's costs, one of the greatest enforcement expenditure is the Division of Investigation. In fiscal year 2021-2022, OMBC's total DFI costs were $270,000. This past fiscal year 2024-2025, total costs nearly doubled to $491,000. With the onboarding of OMBC Special Investigator, which is projected to handle about 60% of overall cases requiring formal investigations, OMBC is projecting a minimum cost savings of $150,000 per fiscal year in these formal investigations. OMBC plans to continue to utilize DFI services on a case-by-case basis, especially in those cases that can result in criminal filings or that may require search warrants. However, most cases have been identified to be at lower level complexities that a special investigator is able to handle. I'd like to point out two charts. The first chart below is the total number of cases referred to DFI by fiscal year for the past 5 years assigned to sworn and non-sworn investigators. It's important to note that DFI is made up of mostly sworn investigators, and therefore most of our cases have gone through the assignment of a sworn investigator, even though the class and complexities can be handled at a lower level. The second chart is a case study of complaint complexities for cases handled through formal investigations for the past 5 fiscal years. Some of these categories, such as unprofessional conduct, unlicensed practice, misdemeanor arrest and convictions, substance abuse, inappropriate prescribing, sexual misconduct, and negligence can all be handled by a non-sworn investigator. I do want to point out, though, that if at any point in time we feel that this special should not be handling the case will be transferred over to DFI. Secondly, the board's newly approved continuing medical education and cite and fine regulations that just passed and will be effective October 1st. The board projects issuing about 68 citations per year with an average fine amount of $1,500 per citation, which may result in a revenue increase of approximately $120,000 per fiscal year. And then lastly, the applications and petitions fee and retired license status regulation, which you'll be voting on this afternoon, is projecting about another annual increase of $424,000 per year. In total, with these 3 changes that I've mentioned, OMBC is projecting an annual revenue increase of approximately $694,000. Terms of communication, as you all know, I represent the prescribing boards as part of the CURES Executive Stakeholder Committee, and I continue to meet regularly with DCA's leadership staff and the Department of Justice. I have calls and email exchanges with Madam Board President Pines to discuss pending and ongoing projects and meeting agendas on a regular basis. I continue to meet periodically with the board's Attorney General Liaison, Ms. Carolyn Westfall, and communicate frequently with Senior Assistant Attorney General Gloria Castro. Continue to meet periodically with members of the Consumer Watchdog Group to gather their input on improving enforcement practices and procedures. And enforcement staff, in particular, Christy Livramento, our enforcement manager, continues to meet on a monthly basis with DFI to discuss any progress on any of our pending investigations. Lastly, we communicate frequently with our committee members. We also communicate with other authorities such as the Office of Administrative Hearing, Office of Attorney General, Department of Justice, DCA in general, other healing our boards such as Medical Board, BRN, Board of Pharmacy, Physician Assistant, and PTBC, California Department of Public Health, California Department of Healthcare Services, the Federation of State Medical Board, the National Board of Osteopathic Medical Examiners, the International Association of Medical regulatory authorities, OPSC, the American College of Osteopathic Family Physicians of California, and lastly, Premier Health, who is still handling the board's diversion program. In terms of our outreach update, I'm happy to announce that the staff and I are working on our 4th edition of our newsletter, Osteoscope. This communication tool is designed to keep applicants, licensees, and consumers informed by sharing board updates and relevant board information such as changes in leadership and staff, our application process, our CME requirements, new legislation and regulation, the enforcement process, and our actions taken by enforcement. In terms of our social media accounts, we continue to post on a daily basis to Facebook, LinkedIn, and X. The board continues to keep our website current with current content, including our enforcement actions. And we have started the creation of our actual how to file our consumer complaint video. The script has been approved and has moved along for production, so we should be seeing that coming up soon. This past quarter, as mentioned, due to budget constraints, we did not attend any outreach events, unfortunately. This is due to our restrictions that we have to keep them to mission critical. We do hope that in the future this changes because we do see a very extremely important and necessity of attending these health fairs and continue to assist our associations, as Holly mentioned, to keep all of our licensees as well as our consumers informed. This time, Ms. Pines, this concludes my report, and I'll be happy to answer any questions from the board members.
Okay, thank you, Ms. Calderon. Let's see, is my thing? Yeah. Okay. First, I just want to, thanks for updating the board chart. It's good for us to see how everybody sort of lines up. I know we've had an evolution of the board chart since you've come on board. And thanks for being detailed about the Purge project. I know that came out of a lot of questions that the public had the last time when we discussed the Purge project, the questions that had come from them. And also the proposed future fee increases and the other revenue that you've identified as we look at our board projections as we get into the next fiscal years and seeing that our reserves were decreasing. That makes me feel a lot better now that we will kind of see that change a bit. So those are my thank yous and comments. Do we have any other board members that have comments or questions about the executive director's report? Seeing none. Do we have any comments from members of the public in the room? Any comments, moderator, from members of the public online?
This is the moderator for members of the public on WebEx. If you would like to make a comment on this item, please click the raise hand icon, or if you're an audio only participant, you can press *3 on your device. And it looks like we do have a couple requests. I'm going to go in the order received. First, I have Michelle, and Michelle, you'll be given 3 minutes to speak with a 15-second warning. Please click the unmute me button when the prompt appears on your device.
Good afternoon. I am Michelle Montserrat Ramos, and I'm with Consumer Watchdog. We are very interested in the special investigator position. You mentioned that an estimated 60% of field investigations could be effectively managed by an in-house special investigator rather than forwarding complaints to DOI. Could you kindly clarify the types of complaints that must be directed to DOI? Specifically, are the 805 reports received by the board eligible for investigation by the special investigator, or do they require preliminary review before being sent to DOI? Additionally, how are cases involving licensees who failed diversion addressed? Are these initially raised as complaints from the probation manager and subsequently investigated by the special prosecutor? We appreciate the addition to your team. We are pleased to learn that you have commenced your committee meetings. Are these sessions open to the public? I fondly recall a time when the medical board held its committee meetings in a public setting, fostering transparency and community engagement. When can the public expect updates on the discussions and decisions made during these important committee meetings? Lastly, I have to add that I found the board members, specifically the physician members' responses to the medical students' questions somewhat alarming. We heard much about political empowerment and financial success, but we heard nothing about your patients or patient care. Only our executive director and our board president made any mention of the patients or the public. Must I remind you that without us pesky patients, you will not make money. We are your path to making money, and we're also the reason why you have an enforcement process and enforcement program. I recommend that you have a similar question answer session for advocates and or the public as well. Thank you.
Thank you.
All right, this is the moderator. Next, I have Maria Ibarra Navarrete. And Maria, you'll be given 3 minutes to speak with a 15-second warning. Please click the unmute me button when the prompt appears on your device.
Yes, my name is Maria Ibarra Navarrete. I'm from San Jose. I'm a volunteer consumers watchdog. I've examined also your records of retention schedule and observed that complaints labeled as closed due to no violation, which is I am quoting that, closed because the subject is deceased, and in quote, closed due to insufficient evidence, are currently retained for only 1 year before being destroyed. However, I am pleased to learn that you revised your schedule to extend the retention period for quality of care complaints involving patient deaths to 5 years. In light of this change, I would like to clarify if another complainant comes forward within the 5-year period and the board determines that their complaints warrants investigation and referral to the Attorney General's office, will the board staff combine the previously retained complaint with the new one and address both cases together? Also, it is my understanding that although you destroy the paper complaint after 5 years, or in some cases, just 1 year, the board retains all complaints with the BREEZE system. How does this introduction of special investigators shape the way our complaints are handled? While I recognize that it could streamline the timeline and lower enforcement costs, I wonder what it means for enforcement process as it relates to families. Will our complaints stay with the board's enforcement staff until they are ultimately forwarded to the Attorney General's office for formal action? What type of complaints can be managed by the special investigator, and what type of complaints must be sent to the DOI? Thank you.
All right, this is the moderator. Next, I have Tracy Dominguez. And Tracy, you'll be given 3 minutes to speak with a 15-second warning. Please click the unmute me button when the prompt appears on your device.
Okay. Hi, I'm Tracy Dominguez and I am from Bakersfield, and I'm a volunteer also with Consumer Watchdog. Thank you for increasing the retention time for no violation death complaints to 5 years. As you know, I submitted a death complaint on behalf of my daughter. This board responded with a simple departure in my daughter's death case, but since then, 4 other victims and mothers of babies who also died under his care bravely came forward. This board recently issued a discipline against his license on behalf regarding the retention of closing a simple departure case, which are retained for 5 years. I appreciate that the case will be retained on Breeze. If my daughter's complaint is retained for 5 years, does the 3-year rule apply to her complaint? When you found that 3 of the recent complaints were worthy of investigation and were evaluated to an accusation stage, why was my daughter's case not added to that accusation? As a family, we do our very best to submit complaints that lead to disciplinary action. As a parent, we equally expect quality of care on a death complaint to fit in that category. My daughter's doctor has a troubled history, harming mothers and babies, resulting in numerous and preventable deaths that simply should have not occurred. In the case of my grandson, his complaint was admonished closed without a review or consideration. While I am grateful that this doctor has finally faced some disciplinary consequences, I can't help but wonder how families like ours can work with the board staff to assure that complaints against doctors, especially those with a pattern of misconduct, are properly processed and led to disciplinary actions. Thank you.
Thank you.
All right, this is the moderator. Appears there are no further requests for public comment.
Thank you. We will move to agenda item number 12. Licensing program update by Machiko Chong, the board's licensing program manager.
I'm sorry, are we able to address commentary made by the public commentary or no? No?
Good afternoon, Madam President Pines, sorry, and board. Attachments 12A and 12B, which I will show on the screen, reflect the licensing population and applicant stats for the last 4 quarters of the 2024-25 fiscal year and provide a 3-year comparison. Currently, there are 16,744 licensed osteopathic physicians and surgeons, 1,216 postgraduate training licensees, 0 temporary licenses, and 1,290 fictitious name permits. The physicians and surgeons population since 2022-23 grew almost 17%. The postgraduate training licensee population grew a 2.44%, and the fictitious name permits issued grew 2.38%. And overall growth of the licenses and permits issued by the Osteopathic Medical Board reflects 14.63%, which is marginal. That's a lot. As we enter the first quarter of the 2025-26 fiscal year, staff is at a high peak for applications received following graduations. But we are happy to continue to report that all applications are being processed under 30 days for those that have submitted all required documents. Sorry, other spreadsheet. There we go. Nonetheless, there are 520 pending initial applications, with 181 of those requesting expedite services. And the application breakdown is as follows. For the postgraduate training licenses, we have 300 applications currently on file that are still pending, and 220 applications for osteopathic physician and surgeon licenses. And in terms of expedite service requests, we have 171 applicants requesting medically underserved area privileges or expedite, 7 applications for military veterans, and, 3 for abortion services. The last update for the application licensing services has to do with our recently approved CME regulatory packet. And staff is preparing to transition from a 100% audit of all renewals to a self-certification process with a 10% population audit. Board staff submitted a ticket with our Breeze team to start working on database modifications. And in addition, letter templates have been submitted to legal for approval. This concludes my update for the licensing unit, and I welcome any questions from board staff or the public.
Board members, any comments, questions? Do we have any comments from members of public in the room? Moderator, is there anyone requesting public comment online?
This is the moderator for members of the public on WebEx. If you would like to make a public comment on this item, please click the raise hand icon, or if you're an audio only participant, you can raise your hand by pressing *3 on your device. All right, this is the moderator. Appears there are no requests on WebEx.
Okay, thank you. Thank you, Ms. Chong, for your report. That increase is alarming, but I think we are we are ready. And you guys are doing a great job too. Yes. Okay, we're moving to agenda item 13, enforcement program updates from Christy Liverento. I always say people's names wrong. Limerento. There we go. That's what happens when you're first name with people. The board's enforcement analyst will now give us a report.
Good afternoon, Madam President, Denise Pines, board members. I'm here to present the enforcement program updates for the last fiscal year. This report involves updates for quarters 1, 2, 3, and 4 of last year. Please refer to attachment 13A, which encompasses the enforcement program statistics. During quarter 4, 9 complainant interviews were offered by staff for quality of care cases, and 2 interviews were completed. During quarter 3, 32 interviews were offered by staff, and 18 of those were completed. Impact statements are an opportunity for patients, their families, and representatives to describe the harm they experienced as a result of the subject's care. Impact statements are optional, and the opportunity is provided to the patient when a complaint case is referred to HQIU or DFI, also known as DFI. Upon receipt of the impact statement, enforcement staff will provide the impact statement to the assigned investigator. Impact statements should include the subject's name, the board's case number, and the name of the writer, along with their contact information. In addition, it should include a brief synopsis of the care that was provided and how the subject's care has made an impact to those involved. Additional information may be requested by the assigned investigator. If an accusation is filed against the subject, the impact statement may be provided to the subject as part of the discovery process, and the impact writer may be called to testify as a witness at an administrative hearing. Board statistics. For statistics, please refer to attachment 12A. Which contains statistics for fiscal year 24-25 in comparison to last fiscal year. For performance measure 1, it covers the amount of consumer complaints, arrests, and convictions received. The unit has received 1,011 complaints and 24 arrests/conviction notices. This is a significant increase of 26% of total complaints and arrest conviction notices in comparison to last year. The increase in complaints received can still be attributed to the fact that enforcement is now initiating enforcement files on applications with prior arrest histories, in addition to more board awareness that the board is receiving through its outreach efforts. Performance measure number 2 is the average number of days it takes for our analysts to initiate a complaint and acknowledge receipt. The target for this performance measure is 10 days, and we are meeting that measure being at 5 days year to date. Performance measure 3 is the average number of days it takes to complete investigations and enforcement action for cases that are not referred to the AG's office for formal discipline. Case aging here fluctuates because it takes an average of all cases, and 1 or 2 very complicated cases can skew these numbers drastically. These numbers include the timeline for desk investigations and DFI health quality investigation units investigations. The target for this performance measure is 360 days, and our cycle time is at 189 days, which is a decrease of 9% from last fiscal year. Not only is this performance measure being met, but this is in addition to a larger workload in comparison to last fiscal year at the end of quarter 4. Performance measure number 4 is the average number of days it takes to complete investigations and enforcement actions that are transmitted to the Attorney General's office. Case aging in this category is at 955 days. The target for this performance measure is 540 days. And although we did not meet the target in this category, it did go down 20% in comparison from last fiscal year. For fiscal year 24-25, the board continues to be well under its performance measures for three of its performance measures. As previously reported, performance measure 4 is the measure that the board has less control over, as this measure takes into consideration the timeline from the Attorney General's office, respondents' legal representatives, and the Office of Administrative Hearings. The board currently has 669 pending enforcement cases, with 81 of those cases pending at HQIU and 24 of those cases pending at the Attorney General's office. Year to date, the board has filed 4 interim suspension orders, issued 4 public letters of reprimand, filed 14 accusations, and 1 petition to revoke probation. In addition, enforcement staff have issued 5 administrative citations, placed 10 licensees on probation, had 2 licensees surrender their license, and 3 licenses were revoked. That concludes my report. I'm happy to answer any questions.
Thank you, Christy. That was great. You guys are doing a really good job just from year over year, quarter over quarter, just, consistent improvements. I mean, the efficiency that you guys are having in enforcement is amazing, even with performance measure 4, that we are seeing some improvement because that kind of was static for a couple of years. So I know that efficiency on our side is there. It's just how do we kind of get more efficiency on the side of the AG's office? And I kind of understand how all of it does work and how motions get filed by people's attorneys and delays happen. And, oh, my attorney was horrible. I had to get a new one. And so I understand sometimes how those things can draw out. But from the patient perspective, they're not looking at that. They're just looking at why is this taking so long, right? So thank you. And thank you for the explanation also behind the numbers. So I didn't have to ask a lot of questions. Do we have any board members?
I have a question, John Cummins. I'm wondering if you know whether the hiring of the special investigator will have an impact on the numbers in PM4, any of the various.
It could. It'll keep the enforcement case in-house, and we will have more control over in-house investigations than those at the Division of Investigation.
Good. Thank you.
You're welcome.
If I may add to that too, just to kind of give it a little bit of an explanation, DFI services all of the boards, the healing art boards, bureaus. Mainly HQIU focuses on medical board cases, osteo cases, and physician assistant podiatry. So we sort of get put into the pool of those 4 departments, and the cases on their side are worked based on statute of limitations. So if there is a short statute of limitations, they're going to focus on getting those cases completed faster. And so our cases in the last couple of years that have been referred have come over to their department with short statutes because of our backlog that we were trying to address here at the board. Having the investigator in-house can allow us to not only, I should say expedite it in a bigger fashion, because we can actually have those cases handled by the special right from the onset. We can skip the desk investigation from an analyst perspective and go straight to the investigator, which is equipped and knowledgeable to lead the gathering of the records and move it along to the investigation, the interview process right away without having to wait. So that's our plan, to identify certain case types that can go and get assigned to this investigator. It's a wonderful thing to have coming in the position that we have this person coming in, because they don't have a caseload at all right now. We've been sending stuff to DFI this whole entire time. And so now going forward, with Christy's help, her and I, we are going to identify those cases that we can straight assign to this investigator from the very beginning, from the moment of intake, so that that investigation process is sped up without having to go through a desk analyst first to make the vetting. They could handle it from day one that it comes to our office.
Are there any other questions by members of the board? Any questions by members in the room? Moderator, are there any questions by members of the public online?
This is the moderator for members of the public on WebEx. If you would like to make a public comment on this item, please click the raise hand icon, or if you're an audio only participant, you can raise your hand by pressing *3 on your device. And it looks like we do have a request from Michelle. Michelle, you'll be given 3 minutes to speak and a 15-second warning. Please click the unmute me button when the prompt appears on your device.
I am Michelle Montserrat Ramos, and I'm with Consumer Watchdog. We are very interested to learn how complainants and the public are embracing the newfound opportunities to participate in the required interview prior to the closure of a complaint and to submit a patient impact statement. These pivotal policy changes were my idea, and our dedicated advocacy team has tirelessly advocated for these important rights for complainants. I recognize that it may take some time to effectively spread the word to the public about these rights, and more importantly, to convey how vital their participation in the interview and submission of the patient impact statement truly is. Encouragingly, it appears that there has been an increase in participation rates between the third and fourth quarters. Stats were not mentioned for the patient impact statement. It gave me the impression that the board may not have received any. However, I learned that one of our team members was preparing a statement, and upon checking with her, she confirmed that her patient impact statement was submitted. Thus, I'm confident that the board should have received at least one patient impact statement. I speak with a lot of members of the public that wish to submit complaints. How can we be of assistance in helping spread the message of the importance of participation in both opportunities? I see that the number of complaints the board is receiving has increased, but I've not noticed in enforcement statistics that the number of cases going to investigation has increased, or the number of cases going to the AG's office has increased. I dedicate a significant amount of my time to supporting families as they navigate the complexities of the complaint and enforcement process. What essential information do we need to share with the public to ensure that a greater number of our complaints receive investigations and advance to Attorney General's office? Thank you.
Thank you.
All right, this is the moderator. Next, I have Maria Ibarra Navarrete. And Maria, you'll be given 3 minutes to speak and a 15-second warning. Please click the unmute me button when the prompt appears on your device.
Hi, yes, my name is Maria Ibarra Navarrete. I am from San Jose. I'm a volunteer with Consumers Watchdog. Regarding your complaint reviews, it is correct to say that the statistics are for the required interview before a complaint is closed. During the third quarter, your stats show that only 2 out of 9 complainants receive interviews, with the majority, I would imagine, declined or didn't respond to the opportunity. While in the fourth quarter, 18 out of 32 family members were interviewed, which was over half of the family members. Is there a way that we can help boards self-promote the required interview option? I am not sure if complainants understand this opportunity that the board is presenting to them. I know I wish I had an opportunity to discuss my complaint, focus on new evidence or evidence that was submitted but were missing from my complaint. Thank you. I've always noticed that describing the importance of a patient complaint statement, but I do not see any stats that reflect how my complaints had the opportunity to provide patient impact statements and how many of the board received. Again, the patient impact statement will provide a decision makers with some information about the family member who died or the person who has suffered lifelong harm. I would really push for this statement because it is important to ensure that the summary of the complainant documentation include references, to the patient victim and the impact of their death or long-term harm has had not only on the family or in the individual, but also on the community at large. As the board, has the board not received any patient impact statements this year? If so, how can we help to conduct outreach and spread the message of the importance of submitting patient impact statements? Thank you.
All right, this is the moderator. Next, we have Tracy Dominguez. And Tracy, you will be given 3 minutes to speak with a 15-second warning. Please click the unmute me button when the prompt appears on your device.
Okay. Hi, I'm Tracy Dominguez. I am from Bakersfield and I am a volunteer with Consumer Watchdog. I am happy to see the numbers of complaints this board has received has increased to 26%. Increased is a pretty substantial increase. Yet I don't see the number of complaints going to investigation or the number of complaints going to the Attorney General's office increasing. What do we need to do to see the numbers of increase moving forward increasing as well? There are a lot of families that are being harmed and a lot of babies dying in my community. The only way that I can see us saving some of these lives is by ensuring, that more of these complaints go to investigation and are evaluated to a accusation stage. What does the public need to do to assure that our complaints reach the accusation stage? Thank you.
All right, this is the moderator. Appears there are no further requests for public comment at this time.
Okay, I want to thank everybody for their comments. We thank you, Christy.
Thank you.
We are now going to move to agenda item 14, a presentation on the board's probation program by Ralph Correa, the board's probation monitor.
All right. Good afternoon, folks. How are we doing today?
Good.
All right. My name is Ralph Correa. I'm with the probation unit for the Osteopathic Medical Board. I'm here today to let you know, as of today's date, I still have 38 licensees on active probation. 5 doctors are still outside of California's jurisdiction. They are not receiving any credited time for their probation. At this time, I currently have only 1 licensee on an interim order disciplinary action, and they are, of course, being monitored by me based on the order itself. I'll elaborate just a little bit on those disciplinary orders so you understand a little bit. So most of those, if not all of them, usually have some type of restriction on their license that they actually have to comply with, whether it's monthly and or quarterly. Most of the time, they usually stipulate to quarterly. They do have to answer to me. If they do have to do biological fluid testing, that is being monitored also by me. If they have to do some type of support group meetings, that is also monitored by me. Any other reviews, I do quarterly reviews with them as well. So just because they're not on actual probation itself, the interim order in itself is disciplinary, pending disciplinary action. Okay, so they are still being monitored by me, and I do meet with them regularly. Okay. At this time, the 1 person that I do have is very active and they are in compliance. Okay. As far as the review of cases, I do conduct quarterly reviews with each one of my cases, whether I speak to them in person, whether I speak to them on Zoom, or I speak to them on a telephone. I can say without a doubt that everybody at this time is currently in compliance. With those compliance checks, I discuss with them everything that's in their disciplinary order. I make sure I discuss with them everything that is I've received from them, and will remind them of things that are supposed to be submitted back to me. And of course, if I need to speak to whether it's another counterpart that they employed with, and or mid-level assistants or employees, I will speak to them as well. I can honestly say I have maintained an effective and thorough accountability of all my physicians on probation. Regarding non-compliance, at this time, we still have 2 physicians that have been issued cease practice orders, and they will remain in cease practice status until either compliance is met and or petition for revocation is completed. And I believe the enforcement monitor did advise you all that one petition for revocation has already been submitted. So we are working stringently to make sure that we, follow the rules and the guidelines set by the board. Okay. But does anybody have any questions and or concerns? Yes.
If any of our licensees, remember the beginning, we used to have a contract with vendor. This is a board member, Andrew Moreno. I'm curious if we have any of our licensees now that are working with our new vendor, Premier, and how that relationship is going, because I know that they were fairly new at the beginning of this year. If you could just touch upon that briefly.
I can answer that, Andrew. So we are meeting with Premier on a monthly basis to onboard them and get them to essentially provide the same services that Maximus was doing. We still have active participants on their roster, all of our substance abusing doctors, and working with them. Ralph actually has all of the probationers testing with a vendor, and particularly a vendor of that we have a contract with ourselves, so that Ralph can actually view all of their test results. But we do meet with Premier on a regular basis. We're meeting with them monthly right now, just to kind of transition all of the services that Maximus was doing over to the new vendor. And this is not just us, but all of the Healing Art boards that are using the same vendor.
Great, thank you.
Doc, if I can just elaborate a little bit on there. I'm sorry, Mr. Moreno, if I can elaborate a little bit on there. So as a director was explaining to you, we have two types of physicians, two types of organizations, basically. We have your doctors that have voluntarily wanted to submit to, some type of, betterment of their personal health. And then we have the doctors that are on probation. The ones that are volunteering are going through Premier. They are being monitored by Premier, and then of course the director and I and Chrissy, discuss the changes or things that are going on to try to find out, make sure everybody's falling in line. Offset from me, the director and I, we have our own biological fluid testing company that I have very direct conversations with them, I would say daily, about who is testing regularly, and I get a response from them usually within an hour, and I get everybody's test results. And if there's any influx of anything, then I will submit something to the physicians that work for their biological fluid testing company. They will go ahead and find out if there's anything in that physician's system, and then I will get the results back if it's pending that doctor's allowed to take specific medications that may hit something, and or if that person legitimately tested positive for something that, or illicit, that they're not supposed to have at all. And then I will take action. So at this time, I can say nobody is tested positive for anything that is illicit. We had a couple little incidents, but it wasn't related to an illicit narcotic. It was related to something that the doctor was supposed to take from their own primary care physician, which most likely triggered that positive test. And then, of course, going back, sending it back up the food chain to the physicians at the testing site, they determined, no, this drug actually did produce, whatever positive mark that came down. So that was, and just so you know, all those records, every time I request something, I retain all that information in an email, and I box it up and I put it in everybody's file. So this is why I keep track of if there's a positive test. Okay, did I speak out to somebody? When did I speak out? I get their response back. I keep that as well. I retain that. So if and when these questions do come up, I can answer them honestly.
Thank you. Any other comments from members? Okay, any comments from members of the public in the room? Any comments, moderator, from members of the public online?
This is the moderator for members of the public on WebEx. If you would like to make a public comment on this item, please click the raise hand icon, or if you're an audio only participant, you may raise your hand by pressing *3 on your device. All right, and it appears there are no requests for public comment at this time.
Okay, thank you, Mr. Correa. Okay, we're going to take a 5-minute break and we will return and move on to agenda item 15. Okay, perfect. All right, we need to establish a quorum. Machiko, can you please take the roll?
Dr. Swain,
Present.
Madam President Pines,
Present.
Dr. Patel,
Here.
Andrew Moreno,
Present.
Dr. Lockman,
Present.
John Cummins,
Present.
or Damien.
Present.
A quorum has been established.
Great. Okay, we are moving to agenda item 15, rulemaking update. This rulemaking is for pending or proposed regulations. And we are joined by Ms. Terry Thorfinson, the board's legislative and regulatory specialist, officially.
Yeah, yes. I am official.
You are official.
Thank you, President Pines, board members. The regulatory update is good news because I want to take full credit for our approved AOA 750-page regulatory packet on CME audits. So it allows for self-renewals and cite and fine updates. So that I just can't.
Bravo.
I wanted to take a moment for us to bask in that success because I know how many times we started that packet in 2018. And so several versions of the boards have looked at all the versions. And as I said, each version, I don't know, 7 or 8 or 10, I didn't keep count. Those all needed to be changes, because all changes that somebody identifies as good. It makes, like in regulatory process, there's not any room for error. If you have error, the regulatory Office of Administrative Law catches you and denies your regulation because of it. So like when somebody along our process says, hey, there's an error you got to change, that warrants the board's, relooking at it, fixing the error. So we did a lot of that and it worked. I mean, even Erica was a little bit reserved. She says, I think it's going to go through because we got some tentative message emails from the Office of Administrative Law, but it wasn't final. You never do anything, celebrate until it's final. And it ended up going through, and it also ended up not having any Department of Finance questions, which was a first for me. Usually that's kind of a hidden obstacle, if you will. That's another reviewing agency. And when they have questions, then you got to answer them. And if they bring up a problem, then you got to solve it. So you're hoping your answer solves their question or concern. And we move on and we get the approval that we need. So yes, so that unfortunately is kind of counterintuitive that even though it got approved July 10th, it doesn't go into effect until October. And as a quick reminder, that was because businesses felt blindsided with new regulatory rules that would suddenly go into effect. So the compromise, and this was a long time ago, the compromise that the legislature made is that all approved regulatory packets wouldn't go into effect right away. There would be a quarterly basis. And so ours, the next quarter from July 10th approval would be October 1st. So we can still celebrate, but it's not totally implemented. So anyways, that's the first update. The other rulemaking package that we're going to talk about did in our process have some errors that were identified. So that's what we're bringing to you. And then the disciplinary guidelines are still in the draft stage. We're going through back and forth with staff and our regulatory attorney before I think we're meeting and presenting it to the enforcement committee for their review. And so this one will be different than the other ones. This one will have a lot of language review and preliminary enforcement committee review, which we haven't done before because in past years we haven't had committees. So this will be potentially a model for future reg packages. And the idea that hopefully will come out of it is very much informed input, because whether it's legislation or rulemaking, the more people involved that can look and identify errors along the way early on, the better. So that's what I'm hoping happens with the disciplinary guidelines. And so right now, drafting stage, rulemaking, if we, going back to the agenda item that we're going to go to next, if we approve the changes, which are minor, then I think we will be able to, hopefully, we're still in the pre-review, so I'm hoping that no more issues arise in that pre-review. But to give you an idea, it hasn't gotten out of the Department of Consumer Affairs review, as they call it. So it kind of ping pongs back and forth within the department, within our regulatory attorney, before it is finalized. And I'm hoping that, in fact, it'll be finalized and ready to go to the director of DCA and then on to agency. So that is my regulatory update for Agenda 15. Any questions?
Any questions by board members? Any questions by members of the audience in the room? Moderator, are there any questions or comments by members of the public online?
This is the moderator for members of the public on WebEx. If you would like to make a comment on this item, please click the raise hand icon, or if you're an audio-only participant, you can raise your hand by pressing *3 on your device. All right, and it appears there are no requests for public comment at this time.
Okay, great. We are now going to move on to agenda item 16, discussion and possible action to reconsider previously approved text and to consider initiation of a rulemaking to amend these following sections that I will read. 1609, 1610, 1611, 1612, 1613, 1615, 1628, 1630, 1637, 1646, 1647, 1650, 1651, 1656, 1658, 1678, and 1690, and to adopt section 1648 and to repeal 1691 in Division 16 of Title 16 of the California Code of Regulations. No.
Well done.
Ms. Thorferson, you will present. I think, is Christy also going to join you?
Yeah, let's see if Christy's here with us, our
Okay.
regulatory counsel. Christy? Has she joined us?
She was on earlier, wasn't she? No? Oh,
yeah.
okay. You feel comfortable presenting?
Yes.
Okay, let's do it.
Okay. This is, as revisions go, this is revision light. And even though it has a title page, which gives you makes you think, oh my God, there's a lot to this reg package. This is just to organize it so that people can see. First is the memo, then is the proposed rulemaking language. And one of the things true, and the reason, among other things, for the memo starts to capture what the discussion is between staff and the board. And also, it allows me to highlight in yellow what we're changing. So at a glance, you can see how little changes we're making versus how many changes we're making. But the second bullet point, which is revised proposed rulemaking, is a clean copy as required by the Office of Administrative Law. So when you're trying to go through and figure out what's getting changed, clean copies don't really facilitate that, but it is a requirement. And then all the other bullet points are requirements of documents the board has already looked at and approved. So But we're required to, when I'm presenting, to talk about this is the final presentation for this whole reg package, not just part of it. So hence the reason. So the other thing would be workload analysis, attachment 6, because we're adding a fee, we added a chart for that. So let me start to just address background wise, the board approved this package other than the revisions. So what I highlighted, if you go down on page 2, the beginning of what we're changing, you'll note that in 1690 that deals with fees, things that are in yellow are the only things we're changing. The things that have underlined or crossed out, those are existing items that the board approved the last time you reviewed this package. So they're still happening, but that isn't necessarily the topic for the review. But since we're also looking at this as a whole and approving it as a whole, you could bring up things that hopefully you don't find errors, but if you find errors, then we would have to address it. Okay, so among the things that we missed is if you look at subsection D of 1690, which is the section for our regulations, and this is where we list the fees and the amounts. And we're adding, just for clarification, license or renewal fee. And to give you a little bit of a backdrop amount issue is we, in 2023, got rid of our initial license fee that was prorated. So it was based on birth month, and it was prorated like from the day that it was approved to your birth month. We had a table that was in our regs that said, if you got your license approved on this date and your birth date was this date, then you paid this much, okay? That was really very inefficient from a processing perspective. So we just went with what the medical board does. You get your license issued on that day, 2 years later, that's when it's due and that's when it expires. And I'm seeing nods, so that was a good simplification. So in drafting this, we thought, well, the fee is the same. So we never really called out that license, the initial one, because we didn't want to use the word initial. We got rid of the initial in statute. So it's just more readable to have license or renewal fee. They are the same, but there is, when you get charged, your first time you pay for your license, that's an initial amount, is still the same since we got rid of the initial. So I think we were a little bit overcorrective when we got rid of the initial license, that we didn't put enough clarity in there. So that one is just to try to clarify what we're meaning. They're both the same price. The next yellow on sub F, active biennial license, is 200. Again, we are adding the words active biennial license to the existing wording, which is delinquent, because we had a delinquent fee. And when we start making changes in the prices, then we had to change and create different prices. And what we had missed is the inactive delinquent fee. There's an opportunity, and I'm going to refer back to Erica's presentation about budget, is the kind of the reason we're doing this is we cannot legally raise our fees until we're maxed out in our regulations to our statutory limit. Okay, so this may seem, I don't know, nitpicky or whatever, but it is our path to being able to put forth fee increases to deal with our budget. So it's not just a small couple of words. And as it turns out, when we changed the amount, delinquent fees, we didn't used to distinguish. Now, because the inactive is a different price and the active, we are now distinguishing the difference. So we had to add the words to delinquent to be active biannual or, and then the delinquent inactive, that's the one we missed. And DCA budget staff pointed out that, hey, you guys don't have a delinquent inactive biannual license fee. And this is based, 199.50 is based on the statute that it can be half. Okay, so half of what we added, if you look at E, existing approval for the inactive certificate is $399. So then if you divide that in half, you get $199.50. So it's not very much between the inactive or active, but playing with the rules on, we had to follow the rules to literally max it out. And this was the direction that we were given by budget staff at DCA. This would be the max. So that's how we arrived at this missing fee as well as the amount for the fee. And then if you look down on the next page, page 3, we have some more yellows. In the reference section, we're just adding additional statutes to reference as sort of a technical change, not so much substantive. But the substantive change is in the second part of second revision, which is adding all the yellow about electronic format for uploading. And this is to effectively deal with getting into the digital age and being able to accept things, because everything was kind of frozen in time, and like photographs, for example, were passport photographs, and increasingly people were like pressuring us, well, why not a digital? And, and so this was what our response was, actually our regulatory attorney's response was to all the different formats. Erica checked it out with IT to make sure we weren't missing any. And so the purpose of that is because it's an opportunity to add language, we're adding this language so that it would allow for us to accept more digital information. And I will say that digital information and AI will pose some hazards for the board in verifying. I remember DCA's IT chief talked about during COVID why we shouldn't be hesitant to accept electronic things. He said that there were always unique signatures, digital signatures or documents that can be traced back. But with AI, I don't know. The rules kind of change. It's kind of like a paradigm shift. So with the ability to deep fake things, digital poses potentially a new world of security and verification of whether someone's documents are really legit or not. So, but in any case, we can start to pave the way for digital. And that's kind of the summary of the changes for purposes of the rulemaking package.
Okay.
Christie's on? Okay. Christie, do you want to add anything to the rulemaking package? I just did brief overview on the changes.
So this is Christy Shield, Regulations Counsel for the board. So I think that the memo is pretty self-explanatory. These were changes that were primarily brought to our attention by the budget office. And then while I was looking through the other language, I noticed some areas where we could do some additional clarification. OAL, now that they know we do accept electronic applications, they do want to see some specificity when it comes to how things are accepted in the digital world and what formats are accepted. So you'll see that we added all the different file formats that are currently accepted through Breeze in the regulation package to reflect what we're currently doing online. So if you have any questions, feel free to let us know. Thank you.
Thank you.
Thank you, Christy.
Board members, do you have any comments or questions? No? Okay, so before I go to the public for comments, so we need a motion
And there are motion A and B.
Okay.
So if you look down on page 4, there's some direction. I don't know, Christy, if you want to explain the motions. She worded these motions so that they
Okay.
would be absolutely clear.
Okay.
Right. So if you don't have any changes to any of the proposed text that we have in the package today, then we request that you move the first motion. If there are things that you would like to discuss that you think need to be further amended, then we'd be looking at the second motion. But I haven't heard anything from board members regarding any of the text, so I'll just turn it back over to the board.
Actually, I do have a question about, I guess this is page 3 under the heading 2A. I'm, and by all means, throw things at me if you don't want me to bring this up, but I'm not sure modernizing our process to accept electronic files. I'm not sure we're meeting what is really desired by our constituents at this point, because we still have to take a physical picture or print it out, sign it, wet ink sign it, like it's the 20th century, and then scan it back to then send it in. That doesn't, I'm not sure what that serves other than to kind of, it doesn't really make, it's kind of like in medicine, we're still faxing things. It doesn't make any sense. Like, I mean, all we're doing is saving the person mailing that paper photo, and we're not really improving the speed or most people's photographs now are in electronic format from the get-go. So they're gonna have to find a way to print it out, put a wet ink signature on it, then scan it back, and then submit it, which doesn't help them. And I don't think it does anything to help us. Is that something that we can question?
There might
I
be
guess
some confusion
I'm
with
not,
that.
I think I'm not understanding, because the current proposal strikes the requirement of a signature, a wet signature, which is in current regulations. So you'll see where it's struck out there, and it's replacing it with them uploading a digital photo in any of these formats. So there's no longer going to be a wet signature, a printout, wet signature, scan requirement. We're moving away from that, and we're moving towards a digital only submission process. And again, my understanding, and staff can correct me, is we're just trying to update your regulations that are 40 years old to conform with what the current modern Breeze electronic portal submission process looks like. We're just trying to reflect what you're doing. So that is what all of this is about, because I think, I've done this with other boards. We're moving away from the mail paper process to electronic form and throughout the department. There's been a lot of boards that had submitted updates to reflect that. You're one of the latest boards to do this, to fully update their application and licensure process to reflect this new online Breeze process, which is already implemented. So again, I'll turn it over to Machiko and Ms. Thorfinson. Confirm that.
But you're okay.
I got confused by what was yellow and what wasn't, and what was. There's a lot happening there, so I apologize.
Okay.
I have a sort of a technical question. This states that photos can be uploaded as WAV and MP3 files, but those are audio files. I know you can embed a picture into a MP3, but I think WAV is purely audio. Just the whole thing seems bizarre, but
I think they're trying to we don't know where it's going. There could be like some futuristic way to do a live video photo. I mean, it's all changing so quickly. I think they wanted to make sure that all of the current extensions in the universe for any kind of content to be uploaded was actually in there.
But oddly, MP4, which is a video file, is
Yeah,
not there.
I saw it too. Yeah.
Yeah.
I don't know what, this is Christy Shield, Regulations Council again. So I be complete, full disclosure, I am not a technical person. So I just asked the staff, like, what will Breeze accept? What will accept? What formats? Are there limitations? If there's ever a limitation and we're like, this is the only format, like we'll only take PDF, we would have to put that in regulation because it's a limitation on people's ability to submit information and it therefore is regulatory. So I said, what formats do you accept these pictures in? And so this is what I got. I mean, we can have staff go back and double check, but this is what I got. And so that's why it reads this way. I'm relying on the staff and their interactions with the OIS team to tell me what the formats are, because that is the current standard and regulation. If we're going to say how an electronic file is accepted and what formats are accepted, we have to list them in the regulation.
Christy, and I can go ahead and confirm that this list was given to us by Breeze, and it is all of their current types of electronic formats that they're accepting at the moment. So it is a complete list from the Breeze team themselves.
Now, if this changes in the future, we will have to come back and amend the regulations to so maybe, if they do find out there's a mistake in here, we can always bring it back and take it out.
Okay, great. Okay, are there any other comments by members before we move to a motion? So, our motion is approve the proposed regulatory text for 16 CCR sections 1609, 1610, 1611, 1612, 1613, 1615, 1628, 1630, 1637, 1646, 1647, 1648, 1650, 1651, 1656, 1658, 1678, and 1690, and to repeal CCR Section 1691 in attachments 1 through 5, and to submit the text to the Director of the Department of Consumer Affairs and the Business, Consumer Services, and Housing Agency for review. And if no adverse comments are received, authorize the Executive Director to take all steps necessary to initiate the rulemaking process, make any substantive changes to the text and the package, and set the matter for a hearing if requested. If after the 45-day public comment period, there's no adverse comments received and no public hearing is requested, authorize the Executive Director to take all steps necessary to complete the rulemaking and adopt the proposed regulations as noted. I need a motion on that. You don't have to repeat it.
So moved.
Okay. Can I get a
Matthew
second?
Swain.
John Cummins, I second.
Okay, great. Do we need to do a roll call here?
Board
Yeah.
members.
Okay. Board members have already asked for comment. Do I ask after I've said it?
We'll need to take public comment before the motion vote.
Okay, okay. Are there any comments of members of the public in the room? Are there any comments, moderator, from members of the public online?
This is the moderator for members of the public on WebEx. If you would like to make a public comment on this item, please click the raise hand icon, or if you're an audio only participant, you can raise your hand by pressing *3 on your device. All right, and it appears there are no requests for public comment at this time.
Okay, Machiko, can you take the roll, please?
Yes, ma'am. Dr. Swain,
Aye.
Madam President Pines,
Aye.
Dr. Patel,
Aye.
Andrew Moreno,
Aye.
Dr. Lockman,
Aye.
John Cummins,
Aye.
Cora Damian.
Aye.
Motion carries.
Okay, great. Moving to agenda item 17, discussion and possible action on legislation. Ms. Thorpeson will continue to present the report.
Okay, thank you, Madam President, board members. here we are at the ledge season. I wanted to kind of give you an overview before I talk about a few of the bills. There's a significance in the status. What does it mean when something's in appropriation committee as opposed to like Senate Health? And the answer is it's gone through the policy committees. So all of the feedback and, our letters of positions expressing our opinion, that goes to policy committee. So after a bill gets out of a policy committee and goes to appropriation, that means the policy conversation in terms of the legislature is over. Okay, so when you look at the status of these bills, all these bills that are either in Senate appropriation, and the way that it goes is if the bill is an AB, it started in the Assembly, and so it has to finish in the Senate. So to be on its way out of the legislature, potentially, it should be in the Senate if it's an AB bill, and the reverse is true if it's a Senate bill, it should be in the Assembly. So anything that's in appropriations has passed the policy committee. Anything that, and I've noted that things that are still in a policy committee have either been held because sessions have 2 years sessions at certain point, like next year is going to be the second year of a 2-year session. And so things have to get out. There is no carryover. But in the first year of a 2-year session, authors have the ability to hold things if there's some problems with the bill. If they can't resolve it fast enough, they can then work on it next year, next legislative session. So that's the significance of held under submission or still in a policy committee. So going through these, you can see that most, the first two that we supported are in appropriations. So they passed through and been approved by the policy committees. The AB 360 is held under submission. There's issues the author's trying to resolve with that, and they decided to hold and deal with it next session. The bill's still active, or technically will be eligible to be active next session. The other one, the AB 432, for example, that's in Senate Health. Okay, so that bill's had some problems. And so that's why that is not automatically yet in appropriations. The other ones, as you can see on that first page, they're all in our position bill, they're all in appropriations, except for 1215, 2-year bill. They're going to work on that next year. And the only one that I think of all our positions, and this one was an opposed for SB 508, this was the telemedicine license exemption expansion. I think that our arguments and the medical community's arguments, the medical board did resonate with the legislature. I think that they realized that while they supported the expansion that was sort of narrow, but one that just totally took the jurisdiction out of the telemedicine situations in a life-threatening terminal condition. They were willing to do that one. And so then, as I expected, the next session, there's another bill that had initially, this SB 508 had all cancer, all stages, would be eligible. And that was quickly amended by the first policy committee, which said, whoa, that's too broad. And then subsequently that it didn't get narrowed enough. And I think the committees that reflected the legislative policy felt that they didn't want to keep expanding this telemedicine license exemption because, as we had testified, the board doesn't keep track of that statute. We don't have jurisdiction, when it's license exempt. So there isn't a way, it doesn't make any sense to put any provisions, expand the license exemption, and then put provisions in there because we're not enforcing the positions because we lack jurisdiction. So I think that is the reason that bill right now is held in committee. So that did not get out of committee. It's not in appropriations. That's probably one of the only ones on the opposed section that I think that we had some part in the influence of opposing that. The other opposed bill, AB 460, about radiologists, this was also an extension of direct supervision by telemedicine. We opposed that, and that they did make some more specific amendments that requires someone on site that is qualified to step in to be the direct supervisor to, so there, it isn't really just telemedicine. There has to be a backup of someone. And the concern that I had expressed in the letter was the telemedicine was, or telehealth was not an appropriate vehicle for direct supervision of lower level staff, and that there was a risk and particularly in this radiological scenario, that if there was an immediate need for like for an intervention because of contrast, you know, allergic reaction, that there had to be a physician and they had to be available immediately. So that was put into the bill. I don't think it helps, but I will say this bill is a good illustration of where we're at in medicine. You know, some of the students alluded to, like, where are we, you know, in terms of the forces. These bills are saying that there's a physician shortage and we don't have enough anesthesiologists. And so we're willing to either give another non-physician profession the ability to perform those otherwise physician practice of medicine. And the legislature seems willing to do it. And so we are not, even though we were united in terms of the medical profession, we were not the only ones that opposed it. The legislature is open to it. And so we are unable to necessarily stop it. And this is not the first year that that's happened. A lot of the changes in scope of practice for mid-levels that occurred during COVID, it's a trend, but it's, you know, sort of an alarming trend, particularly in the case of, you know, where there's harm that could be done if there isn't a direct physician. So the one that we haven't had much luck with is the, let's see, I lost my screen. The anesthesiologists, the nurse, certified nurse anesthesiology bill. That one, the legislature looked like there was some recognition of some of the issues that were raised. And one of the issues that I raised in our letter is that the existing wording, ordered by physician, that's in the statute should include the implication or implied meaning of physician supervision, so that we're in a strange position of wanting to, you know, we don't really need the change if it was interpreted correctly, but now we got a lawsuit and an order interpreting the statute to say if it's not listed, i.e. the word supervision, then the legislature didn't intend it to be. So in the letter, I said, you have to put the words supervision in light of the court case and the court order. And so the progress we did make is they did keep adding the word physician ordered. But what they didn't in the amendments is add the word supervision. So it doesn't really fix the problem. It's still in a, you know, a vague statute that makes more changes that suggest that certified nurse anesthetists are able to practice. And the idea was, yes, they're able to practice, but the caveat of the physician supervision is very, very important for patient safety, as well as the meaning of the statute. And right now it's ambiguous. And it seemed like the legislature decided like they wanted to support the nurse anesthetists, and then they wanted to be somewhat responsive to us. So they added those words, but it wasn't the, you know, given in the totality of the court order saying if the legislature wants it, they'll put it in. So the continued not adding the word physician supervision seems to be still kicking it down the road, but it's not helping in terms of solving the problem. And we joined the big list of medical professions. Now, one thing that I did learn, and this process, each of these committees writes an analysis. And so that's how I could tell that they were somewhat responsive to the issues that I think our board raised. But one of the issues that they said is that in order for the Governor Schwarzenegger at the time, to have been able to do what they called the opt-out requirement of a rule by CMS, which Center for Medicaid and Medicare Services, that rule said that the standard is physician supervised anesthesiology unless, and there gave the option to governors to be able to opt out of that requirement. And Governor Schwarzenegger did. And when he did, he was supposed to, and this is what I didn't know, you learn something, every day. He was supposed to have asked both of the medical boards at the time, did we approve of that opt-out? And we never were asked. And I asked my colleague at the medical board, and he doesn't recall, whether they were asked. So this is one of the issues that I'm bringing up because policy committees are done. And so the next step would be the governor. But just something to reflect on. This is the most complex of all of the kind of bills because a lot of times you don't have lawsuits and decisions and stuff and opt out, And so this is still kind of an unresolved issue, but the message I heard loud and clear when I didn't see the words physician supervised in there, that's like the legislature saying we're not willing to put that word in, So that's kind of a big blow on a policy issue in terms of the clinical policy of having somebody other than a physician, a non-physician, unsupervised by a physician. So let's see, any other ones I wanted to highlight? Everything else looks like the AB 667, the interpreters were we got amended out, but for purposes of transparency, I kept it in there. And I think those were the ones that I wanted to highlight on the position ones. Everything else you can see that we either opposed or supported, either got stopped or it's moving on through the legislature. And that legislative session ends in the first week of September. So they have deadlines for when they have to go to the floor. But a point of reference, when you have really good advocacy and you have people you can call to make the big important calls to the people that are in charge of making the decisions, one of those time periods with government advocacy, really not something that happens, but in the private sector, you would be calling the person that would be in charge of, does this bill get out of appropriations? Because that is an issue. It's considered a graveyard for bills. Or you try to have it not go onto the floor. And the way you do that, again, is get it to stay in the appropriations. That's not part of, government advocacy. So it's not, it's not something we do. It's not something I do. I pointed out, but private, trade associations, that's kind of stuff, they could do. And the goal in any kind of advocacy is to have key contacts that can directly call up their legislators, whether state, federal, or local, and tell them what you think. So that concludes my legislative report. Questions?
Yes.
Okay.
Did you say that CMS requires physician supervision, but then Governor Schwarzenegger opted out? Okay, so
Yeah.
CMS requires it.
CMS still requires it. So the thing, if you recall, when I set this issue up, to take a position, among the background issues was the fact that CMS does have non-physician billing codes. So that's an indication that they accept, non-physician anesthesiology services. But their policy, unless you opt out as a state, and it's done by the governor, is that the model is still physician supervised. So there's a smattering. I think the statistics I gave you, about a third of all of the anesthesiology in the nation were being billed by non-physicians. And so it's a significant amount. The ones that are having that are usually states that have changed their statute to make it clear that either a physician or a non-physician can provide the anesthesiology. So the fight in California is, I think the nurse anesthetists are wanting to make it be California to be one of those states where it's clear that they can perform anesthesiology without supervision. And again, the way that this bill is worded, together with the way that the court order in the lawsuit was worded, is unless, according to the courts, the word supervision isn't in there, then the legislature doesn't want it. And this is an opportunity, as all bills are, to add the clarifying language. And that clarifying language would be physician supervision in addition to physician ordered. So we're still not there yet. And it's rural areas where this is happening. And that's true. The driver of this bill is from a rural area. You think of California, 80% of California is rural. So it's not a small issue. I don't take it, our position lightly and insensitive, but it is a patient safety issue. And there is a difference between a non-physician and a physician in terms of performance of a high risk, procedure like anesthesiology.
Any other members have comments or questions about any of the bills? Any members of the public in the room? Moderator, is there any members of the public online that have a comment?
This is the moderator for members of the public on WebEx. If you would like to make a public comment on this item, please click the raise hand icon, or if you're an audio only participant, you can raise your hand by pressing *3 on your device. All right, and it appears there are no requests for public comment at this time.
Okay. Ms. Thorfison, I think that is it. Thank you so much. Thank you for putting that matrix together and giving us an understanding also when things are still in a committee to when things are in appropriations. It's always good to kind of understand some of our legislative process, especially as it relates to these bills. So we appreciate that. Thank you.
You're welcome.
Okay, we are moving to, I believe it's agenda item 18. Future agenda items and meeting dates. So just as a reminder, our next board meeting is November 13th at DCA. So we'll be at headquarters. It would be great if we can pull up our calendars and look at putting some dates together for our next board meeting. Okay.
I can bring up that.
What do we have scheduled? So
Machiko, if you want to bring up our last year calendar so we can kind of use that.
Okay, January 22nd is what you requested for.
yeah, I think we all agreed to January 22nd. So if you can just check your schedules to make sure you have January 22nd of 2026 on your.
Sorry, which calendar do you want me to pull up? Because I would have to upload it into to.
Oh, no, I was just going on our website
Oh.
just to look at our past meeting dates so we can kind of
Gauge.
gauge on that. Yeah.
So then our next one, well, last year it looks like we had February 13th. Now we have January 22nd. So then would we be looking at a date in April?
After our February, it's typically May. So May. So January and then
Well, we're
April,
meeting
May.
earlier.
Okay.
So I
April.
think that we have to stay inside of a time frame. Okay. So then if we could look at our April calendars.
I can do any Thursday. Great.
So for April 2026, you have the 2nd, the 9th, 16th, 23rd, or 30th.
When is Easter? The 5th of April? Okay. Okay.
It's not even on.
Okay. So we just stay away from the first one. The 5th. So maybe the 16th? Oh, yeah, after tax. How does the,
Or the 23rd.
the 9th, how does the 9th? Is the 23rd work within that time frame?
Yes.
Okay. Okay.
We could just set some dates and then we'll work
Yeah.
out the locations. Yeah.
So everyone, does April 23rd work for everybody's schedule?
Works for me.
Okay. Okay.
I'm not sure any day in April works for me. April's a rough month for me next year.
Okay.
And then it would be July.
Okay, next dates we're looking at is July. I have to do late, because I'm always with FSMB the first week and then we'll do a big family vacation.
Do you want to
So like-
set 2 dates and then we can come back and say?
No, let's just do
Okay.
that. So how does July 23rd look for everyone's schedule? July 23rd, of course, it's a Thursday. Okay. Yep, works. Okay, let's put July 23rd. And then our last date will be November? October? Oh, we're gonna do it in July, August, late July. It still has to be October.
Late October or early November.
Okay, let's look at early November. So early November. The 5th, the November 6th, November 6th, it's a Friday.
Oh, sorry, November. Sorry. Yeah, you're right.
November 6th? I'm sorry, yeah. November 6th. Does that work? Okay, so we're gonna put these dates. The team will look at locations to these dates. We might have some changes, so we'll come back to everybody once we're able to lock it in. Also, in January, we want to do the Hill Day. So if we did that, it would be January 21st. So for those of you who are interested in representing the board and meeting with our board, our legislators to talk to them about, who we are, what we do, so that there's clarity to them so when bills come to them, they understand who we are and help to protect our identity. So you don't have to let me know now, but like within the next 2 weeks, so we can plan to do that. Okay.
Future agenda items, I think.
So are there any, so that was our, our schedule, trying to get that together for next year. Are there
We can
Yeah.
I'll send those out to you.
Perfect. Is there anyone who wants to add a future agenda item to our, for a future meeting?
I have a comment
Okay.
that may or may not be appropriate for a future agenda. I noticed that 16 California Code of Regulations, Section 1697, is about conflict of interest code for Osteopathic Medical Board of California. But I also noticed that it's actually not published. It's available through some repositories in Sacramento.
Mm.
And I looking at the history, it looks like this is from the last century. It hasn't really. And I'm wondering if now that it's 2025, it would not be that difficult to make it available online. The rationale, it says, note, it having been found pursuant to Government Code Section 11344, that the printing of the regulations constituting the conflict of interest code is impractical, and these regulations being of limited, use, rather than publishing them in full, are just available through these repositories in Sacramento. But that was all done before, the internet was ubiquitous.
Mhm.
So I'm just wondering if that's something that we can. So that's my comment. I don't know what would be involved. I don't know if it would be onerous. Maybe it wouldn't be justified given the limited applicability, but if it's relatively simple, it might be beneficial.
Okay.
I just conceptually, I don't like the idea of having laws or regulations that are applicable to members of the public not being available widely and having go somewhere or write to somebody. That's so last century.
Okay.
So that's my comment.
Okay.
Thank you for bringing that up, Mr. Cummins. We do have a section on our website that's dedicated to laws and regulations, so we'll see how we can publish that. So it's readily available. There is, if you go on our website, it's the last tab, and then you have laws and then regulations as a general topic, and then we can make sure that that's readily available once you click on there.
Yeah, that might be a good solution.
Perfect.
No.
Sure, we're getting to substantive discussion.
Oh, okay. Okay. Are there any other members that want to add a future agenda item? Okay. Are there members in the public that have any comments on our meeting dates? Anything that we just talked about on agenda item 18 in the room? Moderator, are there any members of the public online that want to make a comment on agenda item 18?
This is the moderator for members of the public on WebEx. If you would like to make a public comment on this item, please click the raised hand icon, or if you're an audio-only participant, you can raise your hand by pressing *3 on your device. It looks like we do have a couple requests. I'm going to go in the order received. First, I have Michelle. Michelle, you'll be given 3 minutes to speak with a 15-second warning. Please click the unmute me button when the prompt appears on your device.
Good afternoon. This is Michelle Montserrat Ramos from Consumer Watchdog. I actually have two agenda item proposals. One, requesting that board staff work with the Department of Public Health on a presentation on 805 reports and hospital disciplinary actions, and how the department and the board can work together to ensure that this board is receiving all 805 reports, enforcement actions, and deficiencies. Secondly, also a committee's update. Thank you.
All right, this is the moderator. Next, we have Holly Macris. And Holly, you'll be given 3 minutes to speak and a 15-second warning. Please click the unmute me button when the prompt appears on your device.
Hello again. I'm sure we'll want to be on your agenda to talk about the osteopath bill that we're going to be introducing in 2026. I think January absolutely would be ideal, and then probably updates throughout the whole time. So thank you.
All right, this is the moderator. It appears there are no further requests for public comment at this time.
Okay, thank you so much. Thank you for assisting us throughout this day. I appreciate it. So we are moving to agenda item 19, adjournment of the meeting. I want to thank everybody for traveling in for the meeting, staff, board members, also the young people that joined us today. It was really exciting. So thank you.